This is Criminal Appeal 363/2019. In the conspectus of the aforesaid discussion and the materials on record, we are of the view that the conclusion arrived at by the learned Session Judge Darang in convicting and sentencing the appellant under section so and so does not warrant any interference. The appeal is dismissed.
Item number 2.
Criminal Appeal Jail 50 of 2021. Consequently, we are constrained to come to the considered opinion that the evidence on record failed to pass the test of proof by circumstantial evidence in a criminal trial, as is well settled in the form of the golden principles. Therefore, the criminal appeal stands allowed, and the impugned judgment is set aside. The appellant, convict appellants had been set at liberty forthwith. Next.
Item number 3.
The impugned judgment dated 26/9/2022 passed by learned Special Judge Bongaigaon in POCSO case number so and so is 1 of 2022 is hereby upheld and confirmed. The criminal appeal stands dismissed.
Item number 4. Criminal Appeal 362 of 2024.
The criminal appeal succeeds, and the impugned judgment and order dated 22/8/24 passed by the learned additional session judge come Special Judge POCSO in Morigaon in POCSO case number 285 of 23 set aside. The appeal is allowed. The appellant shall be set at liberty forthwith.
Deeply obliged.
Yes.
Okay.
May it please your lordship, my lord, as this is item number 8.
Item 8
My lord, I have taken consent from the other side. Some instructions are required, my lord,
after vacation.
after vacation. Lordship, 22nd April, kindly.
Wait just a minute. PK Roychud, Learned Counsel submits that with the consent of the other side, matter may be posted after the vacation. Prayer is allowed. 22nd?
22nd April. Okay.
20 to 4.
Interim order to continue.
Interim order shall continue till the next date of listing.
Deeply obliged.
My pleasure, lordship. Praying for item number list 2 for adjournment, my lord.
Item
Item number 2, my lord.
2.
Yes, my lord. For motion list.
Oh, as you wish.
After 25th.
Adjourn for the day.
After 25th.
After this is the matter after 25th April on a date to be fixed by registry.
Deeply obliged, lord.
Next year. Did I get mentioned listing after vacation?
After which? No.
On the lordship on the 20th of April after vacation.
28th of April.
May it please your lordship, I beg to mention item 9 from the daily list. Counsel Mr. R. Senso is out of station. Opposite parties have filed a reply, maybe fixed for hearing any date before 30th of April. Your Honor, because the case in the lower court is
Learned Counsel seeks an adjournment on the ground of the leading counsel being out of station. It is also submitted that the opposite side had filed the objection. Objection full stop. Leaves the matter after the vacation on a date to be fixed by registry.
obliged.
May please your lordship. Lordship, I beg to mention item number 19. In this matter, search sheet has been submitted.
19.
Yes.
Let it come up and we can dispose it of maybe. Let it come up.
May please, your lordship. Lordship, back to mention item number 21. City has not received it. Lordship may fix the matter after view, if possible, 20 or 21.
Case diary is not received. Issue reminder. Interim order is there?
No.
This is the matter immediately after the vacation.
Yes,
On
21.
date should be fixed. Should I fix the date? 23?
Yes, 20.
23.
Obliged.
May please your
Yes.
lordship. Lordship, similar perhaps in respect to item number 16 also, my lord.
16.
The CD is not there.
Okay, let us see.
60. Yeah.
Case diary is
Very note.
issue reminder for the case diary. Interim.
Yes, ma'am.
Interim stands extended till the next date of listing. List the matter on
24.
24th.
Obliged.
May I please, your lordship?
24th. Yes.
I'd like to mention item number 13, your lordship. On behalf.
1-3.
Yes, your lordship.
1-3.
On behalf of senior counsel Ken Chaudhary. your
Yes.
lordship. The matter may be adjourned for a day, Lordship, as he's having some
And
concern.
counsel seeks an adjournment on behalf of learned senior counsel. Just due to some difficulty today. This is the matter after vacation on a date to be fixed by registry. Any interim order?
Yes, Your Lordship.
Interim order stands
No,
extended.
no interim.
No
order,
interim.
Lordship. Can it be fixed in the third week of May, Your Lordship?
30th of May.
Yes.
In the month of May, on the date to be fixed by registry. Okay,
Obliged.
they'll fix that date.
My pleasure, Lordship. So I'm for item number 3, my lord. This petition become infectious, my lord. Petitioner already got arrested, my lord. Item number 3.
It is submitted that due to the petitioner being arrested in the meantime, the bail application has become infructuous. Disposed of accordingly.
Bless, my lord.
Open the item number 1.
Made precautions. This is a regular bail application.
Mhm.
FIR is page 7. May I read the FIR? With reference to the subject that above, I have understand would like to state that today a thief was caught red-handed inside our campus while he was cutting and stealing earthing copper wire from M1 block with some sharp object. The name of the thief is Miasan Ali, son of Hakim Ali of Borpata district, Assam. It comes to be known that the thief resides in some rented house near Khanka, Hatigarh. As per the police interrogation, it has come to know that she earlier stolen other items from the campus, such as cycle, etc. In this regard, on behalf of the resident, requested you to kindly take necessary step for punishing the same from your in. Lordship, in FIR, there is no mention of the time of occurrence when he committed the theft. And Lordship, kindly see the page number 12, the seizure list. Only
It may be there in this thing, time period, okay, time is not mentioned. Anyway, which page should I see?
page number 12.
Yeah.
Only 3 meter copper wire. Page number 12.
19 years.
And
How much? 3-meter long copper wire.
copper wire. And
Mhm.
one wire cutter plus.
When was he arrested?
Here behind the bar from 22 days. He
18.
arrested on
18-3.
18th.
What do you say?
Yes.
Is there? Is there?
Thereafter, after he initially, yes, the present petitioner was arrested, my lord.
He's Miachen Ali.
Miasin Ali.
Yes,
And thereafter, on being leaded, he named one another person, namely page 17, your lordship.
I've seen him. Involved in other offenses. So get the case diary. Okay.
Yes.
And Islam.
And
And Islam Learned Council. Call for the case diary of Hatigaon PS case number 50 of 26. And that's when the accused was arrested on 18/3/2026. This is the matter on
On 24.
Levelers.
Applicant 29.
May I please your lordship, this is a regular bail application. I was arrested on 28/2/2026 behind the bar since 40 days. FIR is at page number 10. Allegation is that on 27/2/2026, complainant 1 Hussein Ali lodged an FIR at Rupohiat PS stating that the accused persons and complainants have a pending land dispute before the court. During the pendency of the said dispute on 26/2/2026 at about 2 p.m., while the complainant and complainant family were working in the backyard of their house, the accused persons, along with their family with deadly weapons such as sword, sticks, iron rods, and pistol, brutally assaulted Hatem Ali, Ramjan Ali, Ashadul Ali, Marajul Ali, and Inara Khatun. The accused person inflicted grievous injuries upon the victims using sharp weapons. The injured persons were initially taken to the police station and thereafter shifted to the hospital for medical treatment. During transit to the hospital, Hatem Ali succumbed to his injuries. The remaining injured persons are presently undergoing treatment at Mokhili Medical College. Lordship, I would like to submit that I am not the actual owner of the land. it is mentioned in the FIR that there is a land dispute between the owner and the complainant and his family. But here I am not the owner of the land. I am just the cultivator of the land. I am cultivating on the land on a sharecropping basis.
Okay.
So there is no mens rea from my side. So when the fight arises, I was not present initially.
Mhm.
I was passing nearby. I went there and I tried to break up the fight. And there is nothing, nothing has been seized from my possession. No weapons has been seized.
Okay. But
In the FIR also, the FIR was
how
against
do we
10.
know, I mean,
Yes.
whether he is,
One person.
I mean, whether your instruction is
Yes.
correct. Anyway, if there is anything, then they can, definitely we can consider. But
Behind the bar since 40 days.
One person expired, another person
That is true.
is still treatment and is under
what is
treatment.
the, what is written in the forwarding report, Mr. Bhattakar? Can you?
Forwarding report, yes, my lord.
I
The
think
arrested accused have been, your lordship may kindly come to page 16, my lord.
I've seen, page 16.
Page 16, very vital portion, my lord, also 16, forwarding report.
This I've seen, yes. This I've seen from the original.
Yes.
Already 2 persons were granted anticipatory bail in the same FIR by the learned session judge.
It will be better to see the case diary because I don't
Yes.
find anything to, distinguish.
Distinguished. Only identified. that is-
Mr. S.
MS Ahmed.
MS Ahmed,
Yes.
Learned Counsel. Call for the case diary of Rupohiyat case number 58 of 2026. The petitioner was arrested on 28/2/2026. They submitted by the Learned Counsel and recorded submission. It submitted that the petitioner is not involved in the alleged occurrence and that he perhaps tried to only break the quarrel between the two parties, which led to the incident. Nevertheless, I don't know. Please don't give an early date after
On-
petition.
On 22/4.
22.
Much of this.
Yes.
May please, your lordship. Lordship, this is a regular bail application. The petitioner before your lordship is one Sudeep Das. He has been arrested on 6/3/2026
Mhm.
in connection with Chanmari PS case number 204425. Your lordship, the FIR starts at page 16 and the operative portion would be at page, the operative portion is at page 16, lordship, starts from page 12. If I may read the FIR, lordship. I, Sushil Kumar Khandela, am the proprietor of Shri Ganesh Trading Co. and its registered office at so-and-so Jagir Road, District Morigao. One Shri Manoj Harlalka, who is a power of attorney holder of my firm, Shri Ganesh Trading Co. since 10/5/2009 to look after day-to-day work by forging my signature, misappropriated the money belonging to my firm so-and-so, was awarded 3 work orders by the PWD Rose Chanmari. On completion of all 3 works, I came to know that the security deposits and the maintenance deposits belong to my firm were fraudulently withdrawn and deposited by Mr. Shri Manoj Harlalka in the name of creating fake bank accounts by forging my signatures. He misappropriated to the tune of rupees 1,48,95,839, so-and-so. Now for the next page, lordship. I was approached and induced by the above named Shri Manoj Harlalka, son of so-and-so, resident of so-and-so. All the 3 aforesaid work orders had been executed and handed over to the respective PW department after proper completion. During the execution of all these works on the payments, bills were submitted into account number so-and-so, State Bank of India, Sonakuchi branch. I had made an inquiry with the PW department on 24/12/24 regarding release of my dues from the department. To my utter shock, I came to know that the security deposit and the release was not made into my duly authorized account, which was associated with respect to the aforesaid work, wherein the earlier payments were made. Rather, the payments were to fake bank accounts managed in the name of Shri Ganesh Trading in so-and-so Federal Bank Limited, Bongaigaon, which are operated by Manoj Harlalka, accomplice Sudeep Das, the petitioner before your lordship. Now, lordship, that is the allegation. Subsequent to this, lordship, Manoj Harlalka, the co-accused in this case, approached this case for pre-arrest bail, your lordship. And this honorable
Yes.
court, order dated
I'm remembering it.
8/12/2025 was pleased to allow him to go on interim bail, lordship, page 33. Now, lordship, at page 33, if lordship
Later it
observed,
was rejected, right?
sorry, lordship.
Later it was rejected.
No, lordship, later on, it was
allowed.
made absolute, lordship, with
Okay.
certain observations.
Okay.
Now, lordship,
Then he
what
was
my
at-
submission is that in this case, initially, lordship, all the sections which were incorporated were below 7, were up to 7 years. Now, when the co-accused was allowed to go on anticipatory bail, subsequently 409 is added in case of the petitioner, Your Lordship. And the notice have been, the grounds of arrest have been served upon him at page 31, Lordship.
But PS case is same.
PS case is same, Lordship.
Janmari 2204.
At page 31, the grounds of arrest is there, Lordship. Arrest section of 409. So that the mandatory provision of 35(3) has been skipped and he has been arrested, and thereafter he has been furnished the grounds of arrest. Now, what my submission is that this honorable court has rightfully observed after perusing the CD that the prime accused, who was the power of attorney holder of the informant, and after perusing the CD, this honorable court had made certain observations. If Lordship comes at page 33.
Okay.
Lordship, if I may read. I have considered the submissions and perused the statement of the accused material recorded by the IO after grant of interim bail and available in the case diary. In the said statement, he has stated about his business relationship with the informant and about maintaining of a joint account at Federal Bank where all work-related payments were deposited. The informant has admitted that the joint bank account was operated by him at Federal Bank, Bongaigaon. He stated that upon completion of all works and receipts of all payments, no dues remain pending between them, but later the informant filed cheating case upon which is a false case. He further stated that the informant was aware of all the transactions. It appears that the petitioner and the informant had a business relationship, and in course of the same, some works were to be undertaken.
I remember now. Anyway. So now he because of the addition of the section, he was arrested.
Lordship.
Addition of the section.
Now, Lordship, my humble submission would be that 409 is in no way attracted to me, because what is my role? I am an employee of the prime accused who has been granted bail by this honorable court. That is my role. And if Lordship peruses the FIR also only once my name comes up, that too with regard to the operation of the joint bank account.
Anyway, what to do now?
Also, that would be my humble submission. He has been behind bars for 32
Cannot be
33
said
days,
that
Lordship.
409 not attracted, but subsequently added, that is to subsequently.
409 is not attracted according to
Attracted because my lord, agent, he is the my lord employee of that, because not only is the agent working.
immediately after vacation. But
Yes.
a couple of days will be just to spend in custody.
He is in jail
Otherwise-
since 6/3/26, my lord. He was
Otherwise,
arrested.
Lordship, the transaction is wholly between my employer and the informant, Lordship. I don't understand from where I come into the picture, Lordship.
Employer and the
Employer and the informant, Lordship. Categorically observed by this court as well as in the FIR as well, Lordship.
He is in jail since
The
6/3/2026.
informant and my employer, they entered into an agreement. I work for my
anyway.
Lordship.
এইটো আগৰ অৰ্ডাৰটো প্ৰায় এনেকে ল'বচোন Heard, you good name?
Lordship and our Sharma, Lordship.
Malan Council, important. যিকোনো তাৰ পৰা ল'লে হ'ল, ফাইনেল পৰা ল'ব পাৰে আপুনি। Para 2 and 3, page 36. Page 2 and 3, please. 2, 3 and 4. Oops. 3 and 4. The petitioner was granted interim anticipatory bail
Lordship,
by the order dated 27.
no, Lordship, not the petitioner before your Lordship.
This is BA?
Co-accused, Lordship.
This is BA, my lord.
BA, Lordship.
No. I mean, the petitioner's name is.
Sudeep Das, Lordship.
Oh, I see.
The employee of the person who obtained.
Just a minute. The petitioner anticipatory bail was Manoj Halal.
Manoj Halal. And the present petitioner is Sudeep Das.
Sudeep.
The bank account is in the name of the present petitioner.
I think we'll have to see the case diary.
Yes.
See the case diary.
Yes.
Otherwise, immediately after reopening,
Yes.
let it be on 20th, 20 if necessary. Okay.
Lordship. Obliged, Lordship.
Call for the case diary of Chanmari PS case number 204 of 2025. The petitioner was arrested on 6/3/2026. It is this Manoj is a co-accused.
He's the prime accused, Lordship. I'm just his employee.
It is submitted by referring to order dated 27/1/2026 passed by this court in AB 2874 of 2025. That co-accused and Manoj Kumar Harlalka, who's is purportedly the prime accused of the case, was granted anticipatory bail by the aforesaid order. First. It is submitted that subsequently section 409 IPC was added and the present petitioner was arrested. This is the matter on 28th April. Okay. 20 April.
Also, they reacted for. Item number 4. Five.
May I please? My lord, FIR is at this, my lord, 10 word, answer 1 of the candidate, my lord. The case has been registered under section, my lord, 126, subsection 2, 124, subsection 4, 117, subsection 2, 303, subsection 3. This is the non-billable one.
These are the allegations.
My lord. But what happened in this case, my lord? The husband of this informant, my lord, Dilshad Hussain, my lord, and his associates, my lord, collected, my lord, 6-7 crores of money for making appointment, my lord, and issued some fake appointments, my lord, to, my lord, one was issued to the daughter of petition number 1, and another was issued to, my lord, petition number 2. In this regard, my lord, the petition number 1, my lord, filed an FIR before the CID, annexure, my lord, 4, page 22, my lord. Here, my lord, the name of the husband of the informant appears at serial number 3, my lord, making all these allegations, my lord. But this FIR was not registered because when they filed this FIR, my lord, they came to know that already a FIR has been registered in CID PS case, my lord, 4, regarding the same issue. That is why, my lord, what happened? The officer in charge of CID case number 4, my lord, issued notice to the, my lord, petition number 1 for existing his evidence in this case. When annexure, my lord, page 26 में close में कहने से annexure 5.
That means they were they paid money for jobs.
My lord.
And then they were cheated.
My lord, they were cheated, my lord, and subsequently what, my lord?
Page 20.
My lord, page, my lord, 25 close में कहने से.
25.
This is the, my lord, notice issued to, my lord, petition number 1 by IO of CIDPS case number 4.
Okay. Who's Bilal Ahmed Azadi?
My lord, he is, my lord, petition number 1, my lord.
In that case.
My lord.
In that case.
My lord.
This was already raised.
My lord. So, on the day of occurrence, my lord, what happened, my lord? The informant and, my lord, her husband, my lord, they attacked, my lord, the petitioner. And petitioner, my lord, too, himself dialed 100, my lord. Then this police came, my lord, and took them to this PS, my lord. And thereafter, my lord, this husband of the informant, that is Dilshad Hussain, has been taken custody by CID, my lord, in connection with CID PS case number 4. Now, my lord, he is in the jail custody, my lord.
So, according to you, this case is false.
My lord, I am, my lord, we are, my lord, ready to cooperate with, my lord, the IO. It will, my lord, allow us, my lord, interim protection. Your lordship may kindly see page 30. This is the, my lord, FIR which was lost by the chief engineer, Authorised department, my lord.
It's confusing. Anyway, what do you say?
My lord, from the, my lord, contents of the present affair, the allegation is that, my lord, the accused person assaulted with hammer, my lord. And regarding that
is true. That is, theory case is there.
theory case is there, and, my lord, regarding that, well, his submission that Water Resources Department has already lost, and regarding that also, my lord, because I earlier, my lord, had gone through, because that is also a true fact, yes. Result. But regarding the present case, my lord, present case, they assaulted with hammer, my lord.
That is,
definitely there is enmity between the parties.
Okay. Third Learned Council, J. Islam Learned Council, and P. Potaku. Invoking 482, seeking anticipatory bail in connection with Dispur PS case 1. So,
173.
In the Azaha dated, in the FIR dated 28/3/2026, lodged by Mosumi Akhtar, it is alleged that when she was coming with her husband in their vehicle, the petitioner and another, accompanied by 7 miscreants, attacked them and assaulted her husband and also her minor son. It is alleged that they also outraged her modesty. They also committed indecent assault upon her. The learned counsel submits that the FIR is concocted and the petitioners have been falsely implicated. It is submitted that the husband of the informant had induced some persons, including the petitioner number 1, to part with money with promise of jobs in Water Resources Department. And
Both the petitioners.
in connection,
Both the petitioners.
both the petitioners. And in connection with the same, they had lodged an FIR dated 18/3/2026 before the concerned police station. But they came to know that CID PS case number 4 of 2025 has already been registered with regard to the same. And investigation is continuing. Full stop. I perused the relevant documents. Full stop. Call for the case diary. However, in the interim, in the event of arrest, 25,000 with 108. They'll cooperate and record the estate.
My lord, only small prayer, my lord. My lord, we have also filed an FIR, my lord, that has been registered as dispute PS case number 174, my lord. That is also annexed, my lord.
It is submitted that with regard to which incident? This incident.
This is same incident, my lord.
With regard to the same incident, the petitioners have also filed an FIR which has been registered into dispute PS case number
174, my lord.
174 of 2026.
26.
You want
Annex
the-
8, my lord.
2026.
26.
That CD should also be called.
My lord. People lordship, please, my lord. I have annexed the FIR also, my lord. Annex 8, my lord.
Call for the case diaries of do the number. Yes. List on
13th of May.
13 May.
Highly blessed, my lord. Deeply blessed.
31.
Earlier one report was called for, report not yet received, man.
The report as called for not yet received. Issue reminder for the same. The interim order passed by order dated 6/4/2026 shall continue in the next date of listing.
On
List on
27/4, man. 27/4.
27/4.
32.
May I please your lordship, same FIR as in item number 29. 22 second was fixed for his daddy. Anticipatory bail application.
Which case? What is
Item 29.
one of the persons died. We call for the case diary. Yeah, call for the case diary along with medical and PM report. List on 22/4.
30.
May it please your lordship. 482 application for anticipatory bail. Page 9 is the FIR, my lord. The allegation is attempt to rape, my lord.
Lot of allegations. Yeah, call for the case diary. This time.
If protection may be
No, it's very difficult. It will be difficult. Because the prima facie, unless there's anything to the contrary. Hmm? Several allegations are there. Third, so and so. Call for the case diary of Krishna, PS case number 10/26. The Consol police station. List on 22, 21,
23 for
23.
Made, please, your lordship.
Yes.
482 anticipatory bail application. FIR is at page number 9, your lordship. May I read the FIR, your lordship?
Page number 9.
Page number 9, your lordship. Sir, it is most humbly submitted that today, that is 21/1/2026, at around 8:25 p.m., while I was returning from Fulfully towards my house in my Bolero car bearing registration number AS0 to this, the below mentioned accused number 3, along with other accused persons coming in a white color Wagoner car, stopped me near the house of Sirauddin in Singaon, Nimtola. The below named accused number 1, 2, and 3, and 1 and 2, and other accused persons came out of the Wagoner car carrying dowel rods, sticks, stones, and damaged my car. I was sitting inside my car at that time. While the accused persons were breaking my car, the local people gathered at that place, and subsequently the accused person took away from my car boot a dash camera, cash 1,52,000, and some RTI papers, and went away in the Wagoner car. The accused person number 1, in order to kill me and has conducted this said attack, the accused person has been threatening me over social media for a few days. Now, your lordship, may kindly come to page number 4, your lordship, paragraph number 5 of our submissions, your lordship, written submission. Here we have mentioned clearly that the accused petitioner, para number 5, your lordship, page number 4, that the informant is a self-proclaimed RTI activist who runs a Facebook page by the name Astitva Foundation, and under the garb of this Astitva Foundation, he files random RTI and other letters of objections and complaints against various government officials, members of Gau Panchayat, and other agencies in order to extort money from such person. The informant has 2 cases pending against him of extortion, your lordship, and here in this instant matter, we are the relatives of the Gau Panchayat members who have been elected, your lordship. He has filed an FIR. Furthermore, your lordship, in page number 5, your lordship, paragraph number 8, we have mentioned why this incident happened, your lordship. Paragraph number 8 of page number 5, that the informant, when failed to prove any allegation of corruption or misrepresentation of fund by the Gau Panchayat members and other relatives of the accused petitioner, he decided to physically attack them on 21/1/2026 and to divert the issue and gain sympathies from the common public. As he runs a Facebook page, he's some kind of a blogger, your lordship, and the most important part here is, your lordship, that there is a dash camera in the car. He says that my dash camera has been stolen and broken, but he does not submit the CCTV footage of the dash camera before the police, because that the dash camera recording is in his cell phone, your lordship. He does not submit that dash camera CCTV footage, and he says my camera has been stolen. He also says some RTI papers has been stolen. Your lordship, entirely fabricated story. We may be allowed to participate in the investigation. Our relatives are the members of Gau Panchayat, and we do not hold any grudge against it. He is the person in return who is trying to extort money from these people, your lordship. We are ready to cooperate with the investigation, and once the dash camera footage is out, everything will be clear, your lordship. Humbly be allowed to so.
Well, he is accused number 1. Present petitioner is accused number 1 in the FIR, my lord. And motive is very clear, because informant is a, my lord, RTI activist, so they tried to attack.
Now, provided if his instruction is correct, then he's also misusing his position.
Indeed.
Yes.
If his instruction is correct.
There is a dash camera, your lordship.
Now, on the other hand, my lord, if that be only because he has some vital documents regarding the involvement of the present petitioners, then therefore, my lord, that is also possibility that they attack the informant.
Heard TL Laskar Learned Council and in Pothago. 482, Lanka PS case number 13 of 2020. The 2 petitioners here in Houston. The allegation, the FIR dated 21/1/26 was lost by the informant, purportedly an RTI activist, with the allegation that on the same day, in the around 8:25 p.m. while he was returning, the accused persons attacked him and caused damage to his vehicle and took away the dash camera and also cash of rupees 1.52 lakhs. The Mr. Laskar Learned Council, drawing attention to para 5 of the petition, submits that the informant is a self-styled RTI activist running a Facebook page by the name Astitwa Foundation. And by way of such activities, he blackmails government officials and extorts money from them. Also, drawing attention to para 8 of the petition, bail petition supported by affidavit, the learned counsel submits that upon not finding any materials against the present petitioners, whose relatives are elected members of Gaon Panchayat, the informant physically attacked them to divert the issue. They submitted that the examination of the dash camera of the car would reveal the complete incident, but the same is in the mobile of the informant, which he has not submitted before the police. Call for the case diary, however, in the interim, so 25,000 is operate and happy. Please stop.
On 15th of May, madam.
35.
May I please, Your Lordship? My lord, anticipatory bail application. The petitioner is 65 years old person, my lord. The FIR is at page 10, my lord. The present case, my lord, arises out of a land dispute, my lord. It is apparent from the face of the FIR, my lord. Moreover, there is a cross case as well, my lord, however, which was not registered by the police, my lord. Page 10 is the FIR, my lord.
Page 10.
Yes, ma'am. May I read, my lord?
Yes, I've read it. Elder brother Australia and then the below named fencing accused person assaulted him on a doubt, sustaining grievous injury.
My lord, this is the allegation, my lord. Moreover, we have also, my lord, filed an FIR, my lord, that is on page 14, my lord. Actually, my lord, what has happened, my lord, on the date of occurrence, my lord, the wife of the petitioner, my lord, engaged a labor in order to, my lord, fence the boundary of the land, my lord. Wherein the informant side was also, my lord, having land adjacent to the land of the present petitioner, my lord. And at that time, my lord, I have stated in the FIR, my lord, page 14, my lord.
But this was not registered.
No, my lord, that was not registered. Moreover, my lord, there is 18 days delay in the registration of the incident FIR, my lord. The FIR was submitted on 14/2/2026, my lord, which was registered on 2/3/2026, my lord. And there is a denial of registration of our FIR, my lord. Moreover, the accused number 2 and 3 was granted bail by the trial court, my lord. And the present petitioner is, my lord, 65 years old, aged person, my lord. So my humble submission before your lordship, my lord, only thing is, my lord, considering the age of the petitioner, my lord. Till returnable date, my lord, some protection may be given on the ground of that, my lord, his age, my lord.
The 2 and 3 have been granted bail by learned court below.
Yes, my lord.
You have a
I have this order, my lord.
Let me see. Yeah, Mohammed Council. The bottom. Ready to bail. Sipajar PS.
Present petitioner is accused number 1.
Yes.
37 of 2026. Sorry.
And GD entry was made on the same day, madam, 14/2/26.
On the second FIR.
No, first
The
FIR.
instant FIR.
On the first day of the thereafter, my lord, after inquiry, the FIR present
18
petition.
days took, my lord.
FIR lodged on the same day of the incident, and thereafter, my lord, registered on 1/3/26, 2/3/26. But GD entry was made on
At
the
this stage,
same.
my lord, I am only on the age of the petitioner, my lord. 65 years age, old person, my lord, having cardiovascular diseases, my lord. He is constantly in fever, my lord.
No, according to, we have to check, we'll take a fresh view. We'll take a fresh view, but the learned court has also said that the grievous injuries are
Yes,
there and they are direct materials against this. You must have seen. So let us see the case diary along with medical report.
But till returnable date, my lord, some protection may be given, my lord, considering the age, my lord. If, my lord, anything comes on the
Age
city,
is
my
not
lord. maybe-
otherwise 482. Call for the case diary of Sipajar PS case now, along with medical report. This is the matter on immediately after petition.
24/4.
This I'll keep here. 24.
Yes.
Obliging.
36.
My lord, FIR is page 11. You also can see in connection of this case, 2 persons has been arrested. And on basis of their statements, now police run after me
What is the allegation?
Case
A
of
vehicle had
theft,
been
vehicle theft.
stolen and it was recovered from the.
Case of vehicle theft.
Yes,
my lord. I am now involved in this connection of this case. And two persons
Kept my
arrested with
vehicle in
red-handed
front of
by the
Honey-
Karbi Anglo police.
Honey Farm. Vehicle is missing.
Two persons arrested with vehicle.
Two persons were arrested with vehicle.
Yes, sir. And their statement, on the basis of their statement, I have been like a police.
What do you say about that?
Well, at this case, theft of a CD may be called for a vehicle.
City call, it may be done, I will.
No, otherwise, whether vehicle.
Vehicle recovered. Or those two persons arrested with vehicle, madam. In Karbi.
Various offences might have vehicle lifters do. And he sought that immediately after reopening.
Till then, my lord protected, madam.
Do not know what is the. Yeah, I'm at London Council. Call for the, I think, he's not named, but
Yes.
the statement of.
Yes.
But that only CD will reveal whether
my
only
lord.
basis of
Correct, my lord,
statement
but
of
on the
the
basis of statement, who
accused
I can be
and
punished, my lord. That is
maybe
the-
my lord CD.
Let the city come.
South
It is
Salmana
only-
base is 150, but CD should come huh,
Yes,
without
but
delay.
city should come.
Yes.
This 30, no? Para-
Yeah, my mail will cancel after receiving city, my lord.
It is Mr. Ahmed submits that the vehicles have been recovered from two persons who have been arrested. And the petitioner is sought to be arrested on the statement of, on the sole statement of co-accused. He is not named in the FIR. So, all for the case that, however, to enable the petitioner to record his statement. Full stop. It is directed that 30,000 at once appear open. This is the matter on 24?
Yes, 24.
24 or what, 27 you want to give?
27, well,
27.
I will be before you within 10 days.
No, I'm not giving him time.
No.
You can appear.
Horizon 6.
Government approval. The matter, sir.
My lord, this is the petition for the quashing of the FIR and lordship find,
Quashing of FI.
my lord, the FIR at case my lord 60.
Okay. Force.
And I take lordship to the FIR which has been lodged by the state authority,
It is lodged by GST authorities.
GST authority.
GST authority.
You actually kindly see at page 65. Ajil also got it, 65.
Okay. Okay.
No. It has come to the light during investigation that the aforesaid taxpayer, a public limited company registered under the Assam Goods and Service Tax Act, has fraudulently availed input tax credit from the 5 non-existent fictitious taxpayers without any actual receipt of the goods or services in gross violation of section 16(2) of the Assam Goods and Service Tax Act. You also kindly noted. Investigation conducted by the Office of the State GST Department coupled with the analysis of data available on the GST Common Portal has conclusively established that the supplier entities from whom ITC was claimed do not exist in their register of place of business, have no genuine business activity, were created and operated solely for the purpose of issuing fake symbols. Thus, the ITC acquired by the company is bogus and fraudulent, resulting in substantial loss to the state exchequer, particularly affecting the state the settlement under the GST revenue. Therefore, my lord, you'll also may skip over on the last paragraph, my lord.
Yes.
The accused person acting in a concurrent has abused the GST framework and commissioned serious economic offences, thereby undermining the integrity of the taxation system by indulging in the financial fraud of such a large scale. The business activity is not only involved in criminal so and so. The acts and omissions primarily attack the following offences. Thereafter, you also can see at page 66.
Register an FIR against so and so.
So in view of the above, I humbly request to register a FIR against the Macro Research Company, its managing director, and so and so. That's the director. Managing director. And prior to that, my lord, he has mentioned that the managing directors, you'll also may see at page 64. Key persons involved. Managing director, chief financial officer, any other person. And now, in the last part, he's saying, register the FIR against the managing director. Now, two issues. I'm reading for lordship, Section 132 of the GST Act, your lordship,
Assam GST.
Well, if your lordship can take up this, the pagination will tell you.
No, this is the central one.
It was unique. The Assam, there is no book because the Assam and CGST are the same provisions.
Same.
You also can only see at page 187. My lord. Section 132.
Right.
Punishment for certain offences. Now, whoever commits or causes to commit retain the benefits without so any of the following: supplies of goods or services without issue of an invoice or in violation. We are not concerned with that. We are concerned with C. Avails input tax credit using the invoice or bills referred to in clause B, or fraudulently avails input tax credit without any invoice or bills.
Right.
Now, the allegation which has been made in the FIR is covered by section 132, and the punishment you'll also find at page 188.
Yes.
The punishment is prescribed.
A to F. So it shall be punishable as exceeds.
My lord, commits any offense so and so.
5 crores.
One shall be punishable in case where the amount of tax evaded or input tax credit so and so well, or you taken exceeds 500 lakh rupees so and so. 1 and 2.
Exceeds 200 lakhs, but does not exceed 5 with a term 3 years and fine.
My lord. Now we'll also make kindly see at page 189. 6.
Okay. Yes, this is the necessary.
A person shall not be prosecuted. 6
Previous
years.
sanction is necessary.
Now, my submission before lordship is to follow, my lord. 1. It is settled law that when the special procedure for punishment and the offences and punishment and the manner of trial is laid down in a special act, then the offence cannot be said to be under the IPC. Now, the authorities themselves are saying they are investigating, they are issuing notices. And in spite of issuing the notices, they have now lodged the FIR by saying that he has committed the offence under the IPC, and they say the FIR has been registered. You'll also may kindly look into 2-3 judgments for my satisfaction, you know.
Oh, no problem. Forgery under so and so, formal criminal conspiracy under. It has been registered under which sections?
No, sections.
So and so, BNS.
BNA sections, my lord.
Okay, I'll see.
Your Lordship, on 61,316 at page 60
Of the compilation?
of the, my lord, of the petition,
Page 60.
60.
Yes, yes, this is there.
The sections have
All
been
the
mentioned.
analysis. No, this provision 132 has not been invoked.
No.
Yes.
My Lordship, I see in compilation, the judgment at serial number 1, it starts with page 1, and I will take your Lordship to para 20. This was in respect of transplantation of the Human Organs Act, my lord.
No.
And para 20, my lord. 1993, my lord. POFA is a special act. It deals with the subject mentioned therein, like offences relating to removal of human organs, having regard to the importance of the subject, only enactment of the said voluntary statute, regulatory statute are imperative. So and so provides for the punishment of the appropriate by the appropriate authority to deal with the matter specified in section 3 of section 13 thereof by reason of the aforementioned provisions. An appropriate authority for has specifically been authorized inter alia to investigate any complaint of the breach of any of the provisions of the so and so or any of the rules made thereunder and take appropriate actions. The appropriate authority subject to the actions provided for in the so and so thus is only authorized to investigate cases therein by any of the provisions thereof, any penal or otherwise. Lordship, I kindly see, my lord, para 22.
Yes.
So and so being a special statute, section 4 of the code, which ordinarily would be applicable in investigation of cognizable offences of the other provisions, may not be applicable. Section 4 provides for investigation, inquiry, trial according to the provisions of the code. Section 2 of section 4, however, specially provide the offences under any of the laws shall be investigated, inquired, and so is tried with relating to the same provisions, but subject to the enactment for the time being in force, regulating the manner or place of investigating, inquiry, trial, otherwise dealing with the offences. So and so being a special act, and the matter related dealing with the offences thereunder having been regulated by reason of the provisions thereof, there cannot be any manner of doubt whatsoever that the same shall be prevail over the provisions of the code. The investigation term of section so and so of the code thus must be conducted by an authorized officer only. Nobody else could do it. For the aforesaid reason, the officer in charge of the so and so police station had no other option but to hand over the investigation to the appropriate authority. I will also may see the second judgment, my lord, at page 16. No, not I will take, my lord, I will take to, my lord, page 14.4.
Para?
Page 44, para 37.
Para 47.
37.
37.
At page 44, my lord.
Page 47.
The page will be, my lord, 61.
61. Yes.
Page 61 at the bottom, my lord, page 37. By referring to the earlier Supreme Court decision, the aforesaid passage clearly shows that the legislative intendment is discernible that the later enactment may prevail. The same is to be interpreted in accordance with the same intention. We have already referred to the scheme of the so-and-so Act, and the obscenities pertaining to the electable gold falls under the scheme of the Act. We have also referred to section 7981 of the Act. Once the special provisions having the overriding effect to cover the criminal act, and the offender he gets out of the net of the FTR, and his case, section 292. It is apt to note here that the electronic format of the transmission are compared by the IT Act, which is special law. It is a settled provision law that a special law shall prevail over the general and prior laws. When the Act in previous position deal with the option law, it covers all the offences under the IPC. And thereafter, last mercy, para 39. In view of the aforesaid phrase, referred to and above, we are of the principal opinion that the High Court falling into the order, though the charge has not been made out under section 67 of the Act,
yet appellant could not be proceeded against section 292 IPC. Now, there is a direct judgment of the Milord Madhya Pradesh High Court on the GST, which you'll also find at page 78. A relevant part at page 91, Milord.
Page 91.
91, Milord.
Yeah.
Para 10, Milord. In the considered opinion of this court, GST Act 2017 is a special legislation which holistically deals with the procedure penalty offences relating GST, and at the court of repetition, this court cannot emphasize more than GST authorities cannot be permitted to bypass the procedure for launching prosecution of the GST Act 2017 and invoke the provisions of Indian Penal Code only without placing into service the penal provisions from the GST Act, and that too without obtaining sanction of the commissioner under the section 136 of the Act, especially when the elect section is squarely fall within the specifics of the offences as enumerated in the GST Act 2017. This would defeat the very purpose of enacting a special statute such as GST Act 2017. As such, GST authorities, instead of conducting such a seizure and conducting proceedings as prescribed under the GST Act, themselves would be delegating the same to the local police authorities, which cannot be said to be the intent of the legislature while enacting the GST Act 2017. In view of the above, this court has no hesitation in holding that the GST authority cannot bypass the procedure prescribed in the GST Act for launching prosecution by simply invoking the penal provision under the IPC without involving the penal provision GST Act, especially when the allegation so level is the result of the such seizure conducted by the GST authority, considered offence covered under the penal provisions of the GST Act, and that would amount to bypassing the procedure safeguards provided in section 136 of the Act, which requires sanction of the commissioner prior to initiation of the prosecution, which is the prejudice to the authority. Letting GST authority to adopt such a course of action would amount to abuse of the processual law, which cannot be permitted. And thereafter, it was quashed.
So now the thing is that the IPC provisions can be invoked only if GST provisions are invoked, or they cannot be invoked at all.
Only GST provisions can be invoked because
IPC cannot be invoked at all.
No.
Or if GST is invoked, then IPC can also be invoked.
IPC cannot be invoked
at all.
For the reason, my lord, that the same offences which has been alleged are offences under the GST Act, for which the prosecution is also provided for, and the punishment as well as the manner of trial, everything is provided for. Now, in this case, what has happened, my lord? A search and seizure proceedings were conducted, and after that, my lord, writ petition was filed before this honorable court, and this honorable court passed an order that no coercive measures shall be taken against the petitioner.
Okay.
Court has said. $57 million.
Page
57.
Okay.
And the relevant part, my lord, at page 59.
Yes.
The last but one paragraph, my lord. The learned AG Assam had placed before the court materials to show that the basis of the present action is intelligence input. Considering the law holding the field in the dissent judgment in so and so, it is provided that while there could not be any blanket order of stay, no coercive action shall be taken against the petitioner. Now, thereafter, my lord, after this, the notices were issued to the petitioner by the GST authorities.
This is with regard to the same case.
Same case.
This was passed. This order was passed. Okay.
So my humble submission, secondly, my lord, as your lordship is aware, they're simply saying that the managing director, and the other persons, without any reasons, the Supreme Court has said, my lord, that you cannot, if your lordship permit me, my lord, I may place one judgment. My lordship, at page 28.
This compilation, which one?
The judgment compilation, my lord.
This one.
This is judgment. Page 28, paragraph 50. Paragraph 50, page number 10 लिखा है.
28.
49 আছে para 50 my lord
50.
at page 43
No, 43 of where? The
Yes,
compilation.
compilation
Okay.
there are 50 yeah, lots of what
Yes, para 50. Yes.
my lord
That's
just
right.
so 4-5 lines my lord
Hmm.
it is now well established that the complaint against the company and its directors, the complainant has to indicate in the complaint itself as to whether director concerned were in charge or responsible to the company for the day-to-day management, whether they were responsible to the company for the conduct of business. A mere bold statement that the person was the director of the company against which certain allegations have been made is not sufficient to make such directors liable in the absence of specific allegations regarding the role in the management of the company. Now here, they are saying the person accused, managing director, now you lost my kindly see, my lord, whether the managing director can look after the issuance of the invoices and all those things, my lord. There is another judgment, my lord. What does it say? At page 16. Para 27.
Page 60.
My lord. And the 11th part of para 27 at page 25. Para 27, my lord. In the middle,
yes,
there is no denying the fact.
Yes.
There is no denying the fact that the appellant happened to be the chairman of the MSCB at the 11th time, but it is settled proportion law. No one can draw a presumption that a chairman of a company is responsible for all acts committed on behalf of the company. In the entire body of the complaint, there is no allegation that the appellant had personally participated in the arbitration proceeding or one monitoring them in the capacity of so-and-so, and it was his instance that the so-and-so was made so-and-so. Now here, my lord, they have not made any statement that how the managing director, all other persons are elected for the commission of the offense.
Okay.
So in my humble submission, this lodging of the FIR, the history of FIR, is actually contrary to provisions of law. And my lord, in fact, yesterday, my lord, this petition came up, the earlier one, this petition came up for the court, and we brought to the notice of the court, this FIR, that in spite of the coercive measures, that the action that no coercive measures shall be taken, they issued the FIR, which also amounts to coercive measures. The court heard it, my lord, and the court said that although quashing, they cannot do it, but they will pass an order that no further action, coercive measures shall be taken on the basis of FIR. But here we are for the quashing, my lord. So my prayer being there that further proceeding in pursuance to the FIR, my lord, may kindly be stayed.
Yeah, at this stage, your prayer is to, of course, notice has to be issued.
Notice
But
has to be issued. My prayer
you're
is for
seeking
quashing
stay
the-
of the investigation.
My lord, the stay of the in pursuance to the FIR, my lord.
Yes. You have received copy, right?
Lordship, I have received, I am appearing for respondent number 125.
125.
125, GST department. If
I am for 6.
Lordship, as my learned senior counsel has stated yesterday, the Lordship, the repetition was listed and the code expresses view that it is code is going to protect the petitioners. Then in that situation, Lordship, any
That writ petition was filed with the what prayer? This is for quashing.
quashing.
Though it is filed
That
as a
was
writ petition.
with regard to the
No, my lord, not quashing. No, that was under the search and seizure, but we brought to the notice of the court.
No, this is for quashing of the FIR.
Quashing.
quashing of
That
the
was not for quashing. my lord.
That is not for quashing. I understand. This is for quashing. That was for.
search and seizure that was done by the
Agree
GST.
by that. Administrative action. Okay.
Here, Lordship, what was the reason behind filing the FIR? Lordship, that complete report I will have to take from the GST department. But going by the FIR, Lordship, and section 132 of the GST Act, Lordship, section 132 GST Act specifies certain offences penal in nature, but it doesn't provide any mechanism to find out the criminal intent of those offences. Here, Lordship has read the FIR. In the first paragraph, it states that it has found some fraud with regard to a five recipient of the transactions. So, Lordship, and there was a non-existent, those recipients. Lordship, to find the criminal intent, authority has to
Yeah,
go before the
investigation
police
can be done,
authority.
no doubt. But I'm repeating my query. Learned Senior Counsel has addressed it, but Learned Senior Counsel says that as per the law, IPC sections cannot be invoked. My question was that whether IPC sections cannot be invoked at all, or they can be invoked along with GST sections. And if I've understood correctly, Learned Senior Counsel says that they cannot be invoked at all.
There is a Supreme Court has also said.
On the basis of this, that governing law, according to him.
Lordship,
anyway.
to find out the criminal intent, otherwise, if it is, it cannot be invoked, then Lordship, there will be rampant criminal
Handicap.
intention for any manipulations. It is only to find out the criminal intent. For the financial aspect, Lordship, the GST Act provides the maximum mechanism to find out the culprit. But to find out the criminal,
It goes beyond that.
goes beyond that.
That is your point.
Lordship.
But that is also covered, my lord, in the section 132. Anybody who attempts to commit or abets the commission of the offence.
No, that is part of that abatement attempt is there, but he's saying that the ingredients of the criminal act which goes beyond what is provided in the GST. That is what you're trying to say.
Yes.
Right?
And my submission is that once the GST law has provided for especially the state,
Self-included, according
any project can be invoked, and that is the decision specifically in the GST law by Madhya Pradesh High Court also.
anyways. So you take notice.
Yes,
Lordship. This I'll have to see about the state. Okay. There's a part dictation about. I heard. Learned Senior Counsel. Serve. B. Chaudhary, Learned Counsel, appearing for the respond number
1 to 5. 1, 2, 3, 4, and 5.
The revenue/GST authorities. Learned.
Yes. Respondent number 6, SS Roy.
SS Roy, Learned.
GS.
Junior Government Advocate for the respond number 6. The instant writ petition on the criminal side has been filed by the petitioners, by the petitioner company and the representatives of the same. Agreed by seeking quashing of special task force PS case number 1 of 2026 under section so and so of the BNS. The gist of the allegations is that the company and the persons named in the FIR responsible for the same, purportedly responsible for the same, have availed input tax credit upon fictitious entities and thereby fraudulently caused revenue loss to the department in violation of section 16 within bracket 2 of the AGST Act 2017. The main thrust of the submissions of the Learned Senior Counsel is that as the alleged offences are stated to be within the purview of the GST mechanism, therefore invocation of the provisions of the penal code are impermissible in law. In support of his contentions, the Learned Senior Counsel has relied upon the following decisions. First of all, it is also submitted that for any such prosecution, the previous sanction of the commissioner has to be also taken in terms of section 132 subclause 6 of the GST Act. it is submitted that the GST legislation being a special act, special law would prevail, and it cannot be it cannot be disclosed by the investigating authority by taking the investigation on a trajectory of the Indian Penal Code, and that such a course of action would be erroneous in law and liable to be interfered with. Full stop. Full stop. On the other hand, Mr. B. Chaudhary, learned counsel, who has received received copies of the petition, submits that prima facie the nature of the alleged offences involving fraudulent activities might travel into the domain of IPC offences, BNS offences, and therefore the BNS, and therefore the investigation does not suffer from infirmity. Full stop. Any submission from your side at this time? Stop. Issue notice upon the respondents. Extra copies may be furnished to the respondent side. Full stop. That's what we have to refer to the decision of the decision. Full stop. The learned counsel, senior counsel, submits that the investigation is bad in law and facts, and that he prays for a stay on the said investigation, at least till the returnable date. I'll just read a bit. I'll see these decisions all the time. Today only. This book is yours, right? I can. We have this book, I think.
If necessary, Lordship may keep it.
I'll return it to you.
My lord. I'm highly obliged. They have also issued notice, my lord, for appearance of the managing director before the police authorities with the book submitting document. I have also challenged that one also.
Okay. Any bail file with regard to this?
No.
No.
My lord.
One minute, huh? Just.
The prisoner was arrested in connection with case number 76 of 2025, a succeeded case, my lord.
Okay.
And he was arrested on 24/8/2025, my lord. Basically, case your lordships take up, my lord, that is FIR, my lord.
NDPS.
NDPS case, my lord. Because from me, it was not, position was not taking out FIR, my lord, that you also will find at page 13, my lord.
30.
13.
13.
With due respect, I could honor to report that on 23/8/2005 at 4:30 p.m. information received from reliable source by the OC Badapur indicated a person named is Samim Ahmed Iqbal, a resident of Suenso, was roaming around Shah Adam Khaki from Badapur, suspect to involved in dealing with substantial quantity of narcotic drugs, while he was carrying in a plastic bag. In the border, acting on this information, a GD entry was made. Subsequently, I was instructed to carry out the operation equipped with seizure and investigation kits, such as a laptop lab, needle, so and so, and then I am duty authorized by the Inspector Uttam Adhikari, Badapur Police Station, as per provisions of Section 41(2). Consists of the following the resource info along with the team that can be skip over, my lord. We have not regarding the seizure, my lord. Then your lordship may kindly come to page 15, my lord. After intercepting the suspect person, I disclosed my identity, and as my team has secured the individual, we began questioning the individual regarding movement. At that time, two independent witnesses who were present were requested to assist the legal proceeding. Later on, both the independent witnesses, so and so, willingly agreed to act as a witness, identified themselves, and explained the circumstances of the situation. Subsequently, asked the subject individual his name and address, who identified himself Samim Ahmed.
Okay.
Then your lordship will kindly speak over. Then your this. That your lordship kindly page 19, my lord. Page 19, that is regarding the seizure, we have not finished to forward. The last part 19, my lord. Subsequently apprehended person, signed, my lord, was further interrogated regarding his entire nexus. During this, he reveals three individuals, Tajuddin, then Sultan Chaudhuri, and Samsul Islam. I'm Tajuddin, my lord, and had visited his residence yesterday at about 12 noon and delivered narcotic contrabands to him for purpose of selling at Bodorpur area. Accordingly, they departed from his residence. He further disclosed that associates had called him, informing they were on their way from Patsagram side towards the Bodorpur side in a car with the intent of jointly carrying out the contraband transaction. As such, the reliable source was immediately engaged to verify the information, learned that they were indeed moving from Patsagram side towards Bodorpur side in a white color Alto bearing registration number. I, along with my team, proceeded there and apprehended the other co-accused person involved. Upon reaching the west side of Naka and started conducting Naka checking. During the course of Naka checking, we observed a white color Alto coming from Pandagram side towards Bodorpur side. Accordingly, said vehicle was intercepted at Bodorpur at Bharat. On intersection, found the vehicle was occupied by total 3 persons, driver and two two associates. Vehicle was immediately cordoned off and vehicle and other items were seized. And seizure list was prepared. Nothing was recovered. No contraband recovered from them. Now the
Okay. These petitioners are, who are these petitioners?
yes,
They
madam.
are Tajuddin.
Tajuddin. Now from the FIR, my lord, it appears that on the basis of the co-accused statement, he has been implicated. And the charge sheet also, the same thing is there, my lord, repeating the same thing, my lord. Yes.
Charge sheet narration.
That you will also find the charge sheet. It starts from the relevant portion starts from page 53, my lord, onwards.
Yes, sir. I think the operative part is, the relevant part is
Relevant.
70.
70, yes, my lord.
70. Prosecution phase, we have to see this long.
Then they say that doing with the accused person were jointly running illegally at so and so. And but so my humble submission that they want to perhaps say that they were in that. Then the page 60 is the relevant portion, my lord.
Page 60.
60.
So,
That is the typing port person. That on doing inquiry, total weight of so and so was seized from the possession of accused Samim Ahmed, my lord. Then on doing inquiry, 1 silver so and so, Maruti Caesar car, 1 liter so and so, was possession of Sultan Ali Chaudhuri, 1 liter so and so, that is screen touch, mobile phone so and so. Mobile sets were seized from different accused persons, my lord, Tajuddin as well as Samsul Islam Talukdar and Sultana. The accused person jointly running a legal break business, as there are many facts revealed during their crackdown on excess of illegal traffic. The PO was visited, sketchman was prepared, and recorded a statement of witness. Seizure witnesses were examined by the inquiry officer. Analysis of CDR revealed that is important, my lord. Analysis of CDR
they were
revealed
present at that area.
the accused Tajuddin and Sultan Ali, Samsul Talukdar were present at Bodorpur area at the time and date of occurrence, and they handed so and so Yame tablet to Samim Ahmed. Articles examination of articles so and so, when the accused person confessed their guilt. So now my lordship says that in view of the judgment of our Tufan Singh, madam,
Yes.
the statement of co-accused is not admissible.
If the only material after completion of investigation is the statement of
Co-accused, my lord.
including
In the charge sheet also it reveals that, my lord, CDR analysis.
yeah. So,
My lord.
as I understand, if
Right.
I've understood correctly, that as the learned counsel has said, if the after completion of investigation in the charge sheet, if the only material is the statement of co-accused,
My lord.
on which basis a conviction cannot be recorded in terms of Tufan, that perhaps you can say, that test of 37 is will be in the favor of the accused. Perhaps you can say. But if there are other materials, then you'll have to see whether 37 is.
Other materials is the CDR says that they were present at Bodorpur.
They were present at Bodorpur.
That doesn't involve any
On its
criminal.
own, it may not be, but if you connect it with others, then maybe. You can look at it like that. On their own, somebody's presence at a place,
That cannot.
it may be coincidence also, but if you connect it with the other factors, then it may be.
Other factors is not that because
that's how I
except the
see.
confession, my lord, there is no other evidence. Confession going.
He's been in custody since.
Custody since more than a year, my lord. No, not. 24/8/2025.
24/8/2025.
24/8/2025.
Trial is in process.
My lord, trial is on my lord here. Already over my lord 17/3/2026 for consideration of charge.
Not
Charge is yet to be
not-
framed, my lord. And
Initial stage, madam.
So that is we have to take a call on that. So the only materials against him are the statement of co-accused and the CDR.
CDR analysis.
Now, sir, whether the CDR can be considered as incriminating.
The
and
CDR, my lord, they have
connected to
stated in their report also, my lord, they have stated, what is they state, my lord? They were present at Bodorpur, my lord. That your lordship may kindly see, in the charge sheet, it was stated, my lord. Page 62, my lord. Analysis of CDR, SDR, CAF were revealed that accused Tajuddin, Sultan Chaudhary, Sultan Talukdar were present at Bodorpur area at the time and date of occurrence. So that by itself doesn't prove that.
It raises suspicion, but cannot be
But there was no direct connection with the main accused also. Had there been a phone recording or phone,
yeah, that is
that would have been a additional circumstance for purpose of corroboration, because phone records as for purpose, it cannot be a substantive evidence. So my humble submission before that itself doesn't prove that they were involved in the selling in narcotic drugs, man, to the main accused.
My lord, here I have gone through the record, my lord. From the record, it reveals, my lord. And statement I have also produced, my lord. Here it is from the statement of the, my lord, arrested accused, my lord, Iqbal Imam, my lord. It reveals that all of the,
yeah, that is true.
my lord, that is
Leaving aside that, CDR. It's very difficult also because they don't get anybody else.
And
But that's the law.
my lord.
It's very difficult for investigating agency also. It links
My lord,
one
my
after
lord,
the
for
other, one after the
Tufan
other.
Singh, my
It's
lord,
like
although
this.
Tufan Singh is there, my lord, for the investigation, perhaps
But
they-
that is the law.
my lord.
But generally also, you know, because the credibility of a co-accused is very less. It comes from that only.
My lord.
The accomplice
And
evidence is very
lordship
weak.
is
It comes
point out,
from
my
that
lord, the
only.
same system, my lord, organized crime, my lord,
First
one after the other,
is
my lord.
embedded in the Evidence Act itself.
My lord.
That the accomplice evidence is, it has to be corroborated.
My lord.
Anyway.
Here my objection is there, my lord, only on the ground, my lord, charge is yet to be framed, my lord. And commercial quantity, my
Yaba
lord,
tablets.
12,000 Yaba tablets, my lord.
What to do?
And section 37, embargo of section 37 will come.
P. Kotoki, Learned
My-
Counsel, and B. Sharma, Learned. Please have a seat.
My-
Booking 483 DNSS, the petitioner Tajuddin so-and-so is seeking regular bail in connection with special NDPS case number 76 or 25 and the so-and-so section pending before the Learned Special Judge Sri Bhumi. Full stop. The said case had arisen out of Badarpur PS case number 153 of 2025, which after completion of investigation was charged sheet under the aforesaid penal provision against how many persons were sent up for this thing?
Total, 4 persons. my lord.
Four accused persons, including the present petition. The alleged recovery of the contraband was it was stated to be from co-accused Sami Mohammed Iqbal. The scan record has been is available. Mr. Kotoki, Learned Counsel contains that the main implication against the petition herein is the incriminating statements of co-accused. And in terms of the law laid down by the Supreme Court, a conviction cannot be based thereupon. The narration in the charge, the court has been taken through the narration in the charge sheet, and it is also mentioned therein that as for the CDR material, the presence of the present petitioner with mobile number so and so was found at Badarpur on the relevant day. The Learned Counsel submits that the same on its own cannot be taken to implicate the present accused person. On the other hand, the Learned additional PP objecting to the grant of bail submits that the rigors of section 37 of the Act would come into picture in the instant case, and that there are incriminating materials in the form of statements of co-accused and also the CDR. The learned additional PP fairly submits that apart from these two materials, the other materials so far has not been noticed in the charge sheet. Can I record? No problem. Stop. I have given my consideration to the matter. The petitioner is in custody since 24/8/2025. Full stop. Leaving aside the statements of the co-accused, the CDR analysis, the CDR material narrated in the charge sheet has to be considered. It states about his presence at Badarpur on the relevant day. However, there is no other material regarding telephonic conversation with other co-accused or the contents thereof. Stop at this stage. Therefore, on the basis of the aforesaid materials, I am of the considered view that the case of the petitioner would pass the test of section 37 of the NDPS Act. Full stop. Full stop. Once that statutory bar issue is adjudicated and passed in favor of the accused, it remains to be seen as to whether the petitioner needs to be granted bail at this stage or otherwise. Full stop. It is submitted that charges have been framed, but prosecution evidence has not started.
Charges have not yet framed.
Charges have not yet been framed, and but prosecution evidence has not yet started. Also, nevertheless, the petitioner is in custody since August 2025. In the given facts and circumstances, the petitioner is allowed to go on bail of rupees 75,000 with one surety of the like amount to the satisfaction of the learned trial court and subject to the following conditions. He shall not abscond. He shall be available for trial if one commences. He shall not hamper or tamper evidence. He shall not in any manner commit any illegal activities, including any activities prohibited under the NDPS Act. Violation of the bail conditions would entail cancellation of the bail. Bail petition stands allowed and disposed of.
My lord, a 22 years old boy, my lord, is in jail since 2nd March, my lord. The allegation, my lord, the FIR is lodged by one Pompey.
He did not receive, my lord.
My lord, kindly have a look, my lord. I am claiming that I am innocent, my lord. And kindly, my lord, have a go to the
Your
facts and
lordship may kindly
circumstances.
peruse page 17, my lord.
A mother of 4 years of children, my lord, filed an FIR, who is in 27 years of age, who herself stated, my lord. And my lord, kindly see, he put a signature and how this FIR is drafted in a very, my lord, well orderly manner, my lord. The FIR is filed, my lord, on 23/2/2026. And the case was registered on 2/3/2026.
At page?
FIR page 14, my lord. It's a long FIR, very well orderly maintained. And kindly see the signature of the, my lord, informant.
Okay.
And before that, my lord, I would like to place how I have been implicated in this case and what is the reason behind that, my lord.
Diary has come.
CD not received. CD not received. That's
My lord,
fine.
kindly see page 4, my lord, para 4. May I read, my lord?
Your lordship may kindly peruse
how-
page 17, grounds of arrest, my lord.
Okay, para 4.
Para 4, my lord.
Let me see that first.
May I read, my lord?
No.
That the petitioner begs to state that the allegations leveled against the petitioner is false and fictitious. The real happenings are mentioned here. The petitioner hails from a poor family for which he went to Chennai in Tamil Nadu for earning his livelihood and to support his family. He worked there in a restaurant in a very young age and later he joined as a security guard under an agency named Apex Alatu in Chennai. The informant, who is a 27 years old woman, mother of one child, approached one day one boy named Ahad, not me, my lord, at Chennai.
that Ahad who hails from the same village of the petitioner, that is Sribu Melon, the informant woman told Ahad to provide a job for her, even maybe a security guard. Ahad then told the informant that one boy named Abdul Haq, that is the petitioner, from her village was working as a security guard in a very good position under agency named Apex Alatu. Ahad took the informant to the petitioner for job as a security guard. The petitioner helped the informant to get job and the informant got job as a security guard. The petitioner and the informant had no other relationship except contact over mobile phone. The informant worked there for a period of 5 months. The performance of the informant was not well, for which she was terminated by the agency. About 6 months back, the petitioner left job and Ahad requested the petitioner that the petitioner can give his job to Ahad by making request to his employer. However, the petitioner had not accepted the Ahad's demand and petitioner given their job to one local Tamil, for which the relationship between that Ahad and the petitioner had fallen in conflict. Ahad made a game plan to harass the petitioner and execute his plan. Ahad told the informant that the employer terminated the informant because of the petitioner, as which made the informant furious against the petitioner. Although petitioner had no role in the matter of termination of the informant, however,
I've gone through it, but prosecution.
Your lordship may kindly come to
Yes,
page,
yes, I've seen that. also.
page 17.
Sent it out.
My lord.
Well, we'll see the case there.
Yes, my lord. CD is necessary, my
My
lord.
lord,
Without CD, my lord.
I have been in custody since
That's
second
true,
month.
but the thing is that
My lord, today-
Yes, my lord.
today-
Concealing his identity, my lord.
misleading of identity. See, I'm
My lord,
criminal intimidation,
My
extortion.
humble submission.
One should not misrepresent. It's not a question of misrepresenting Hindu,
My lord,
Muslim,
whether-
Muslim.
because
You should not misrepresent as an engineer if you're not an engineer.
Yes.
That I'm on that.
My lord, my humble submission. What I'm
That's a
saying.
cheat.
What I'm
That's
saying.
not
my
proper.
lord.
On 21.
What I'm
floor, my
saying,
lord,
my
I can
lord,
fix it.
I have been
If
custody.
it was anticipated,
Well, after hearing
Not
all this, my
anticipated.
lord, only-
regular bail is.
Yes, my lord. Only
difficult.
one CD.
My
was
lord, I am in jail, my lord.
That's true, but there was. it
So,
was-
my lord, what happened, my lord? I will not go anywhere.
My lord, on
1 year,
22/4, I can produce the
my
CD.
lord, 1 year, 1 month, 5 days have already been elapsed.
After reopening, call
Yes.
case that yes, call for is not received. Full stop. Full stop. You want me to record your submission for interim? You want? Because you're.
My
Should
lord,
I record your submission for interim?
My lord, my lord, my lord. What?
Your clients.
Why I'm submitting, my lord. Interim prayer is there, my lord. I will not go anywhere. Your
the
lordship
learned
may grant
counsel-
interim prayer.
Hold on,
interim-
I cannot grant. I'm sorry. The learned counsel seeks interim bail on the length of detention in age of the accused. However,
My lord, one more submission I'd like to place, my lord. What happened? She had done, my lord. The incident happened in Chennai, my lord. Her home was Gulaghat. He took shelter at Hailagandi and filed FIR in Sribhumi, my lord. How these 4 districts have been, my lord, entered and included in this happening, my lord, by the informant, my lord. So is it is a very cloudy, my lord, the circumstances.
anyway, immediately after
on 22/4.
21, 22, any day.
22/4.
22.
Obliged.
Short break.
Senior is on lakh, my lord.
After some time.
37 and 38.
37 and 38. 37, 38, same city.
39 as well, my lord. The lakh matter. The lakh matter, 39. Yeah, please, your lordship.
This one, no? Not sure. Okay. Could you meet her? Could you inform her? Well, amicus,
I did not inform, my lord.
her name is shown. But
Name is shown, but
if you can inform, we can take it up after some time. Okay,
My
we'll
lord.
take it up to.
I will inform, my lord. Obliged, my lord.
Apne personal friend. He has informed. He's informed. So she'll probably see maybe on leaks after some time.
yes.
Obliged, my lord.
My lord, 41 can be after some time.
41.
Oh, yes.
If that matters. CD could come.
My lord, I tried to get the CD, but my lord, unfortunately, my lord.
Yeah, it won't come or it may come later.
No, my lord, IO hai. It will be okay.
They are very busy also at this stage. That's all.
So yes, on the first day itself, you was sent to judicial custody. So I pray you will be granted interim. If there is any material, also rejected later on. Because straight away on the first day itself, he was sent to judicial custody. And when his friend is involved.
It will be
And he has fled away. That is the problem. Election duty.
Oh, that's it.
No, he has been deputed for elections. The case diary, last order, last order, 1, 2, 3, 4. 4 of them. The case diary as called for is not received. And the IO by communication dated 8/4/26 submits and that he has been deputed the election duty. The Mr. Talukdar Learned Counsel reiterating, reiterates his earlier contention that the petitioner, though, can I record this? He was present at the place of occurrence, but he was not at all involved in the
Not at all.
Present at the place of incident along with his friend / co-accused, but he was not at all involved in the incident first. And first. This court will reopen. The next working day of this court would be only on 28th April 1st. So issue reminder for the case diary. However, in the interim, accused is allowed to go on bail of rupees 40,000 with one surety of the like amount to the satisfaction of the concerned learned court and CJMD, subject to the condition that he shall cooperate with the remaining investigation and shall not hamper or temper it.
That's
List on
week
you did 24, 27.
28th of April.
28. March.
We can ready. Maybe get a low pilot, no? Just a minute. No? Just a minute. It's nice.
Please, your lordship. Your lordship, I haven't received a copy of the petition.
Okay. You have a look. You have a look. We'll take it up after some time.
Yes,
It's
your
holiday
lordship.
only. No?
Yes, your lordship.
Just have a look. Okay.
Yes, your lordship.
Will you be able to give the copy?
I have not supplied, but I can supply right now, my lord.
Okay, okay. Yeah, after some time.
Obliged.
Go through it. Anticipate. Did I have query?
Case there was called for and he is on interim.
My lord, in this case, search sheet submitted, my lord.
All
Statement has already been recorded. Also, we run with 3 weeks time, I'll appear for that time.
Let me make it absolute. Can appear.
I'll appear.
First three paragraphs. The petitioner was granted interim bail on 3 Sec 2026. Good stuff. It is submitted by the learned additional at in the meantime, upon completion of investigation, charge sheet has been submitted. In view of the above, the interim bail is hereby granted by so and so it hereby made absolute, subject to the condition that he shall be available for trial if one commences and shall not hamper or temper his evidence. The petitioner may submit fresh bail bonds before the learned court below, whereupon necessary orders may be passed.
Public.
Disposed of.
CS number is 03/26.
Yes.
03/26 dated 28/2/26. 18, my lord, case diary not received. Petitioner is in interim, my lord.
Case diary not received, issue reminder. The interim order dated 9/3/26 shall stand extended till the next date of listing.
On 29/4/1.
Nineteen.
19. Well, in this case, search sheet already submitted, and my lord, already in this search sheet submitted on petitioner is a proclaimed offender, my lord, and attachment order also issued in fact. My lord.
Proclaimed absconder. Proclaimed absconder, then AB will be barred as per the law.
Yes, my lord, yes. Hence this court.
Unless there are exceptional circumstances, Asha Dubey, that other issue, yes, main to.
The IO has also produced the case diary, page 24 of the petition, page 24 order.
PNA has been issued.
And thereafter, paragraph 5, hence this court deems fit to issue attachment of properties of the accused Anjum Hussain. So after proclamation, attachment order.
Yeah, after 1 month.
Yes.
It has to be for 1 month. Then there's no option to surrender.
Yes.
Invoking 482 invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Barpeta PS case number 357 of 24, GR 1179 of 24, which after completion of investigation is pending before the learned court below at the stage of appearance. However, it is pointed out by the prosecution referring to order dated 16/10/2025 and 31/12/2025 that learned court below has not only issued PNA and NBWA, but on the basis of the same proceeded to issue an attachment order as well. In view of the same, and as per the law laid down in
Pradeep Kumar Sharma.
Do you remember the
Pradeep Kumar Sharma versus State of Madhya? Probably Pradeep Kumar Sharma versus State of Madhya Pradesh.
It will not be possible on part of this court to grant anticipatory bail to the petitioner, and accordingly this petition stands dismissed and disposed of. There is one option, however, not here. I mean,
yes,
yeah, there's a Prahlad Singh Bhatti also. It has said, and there is a judgment of our High Court, yes. Pranab Roth or something. It's 2008 that you can appear before the Sessions Court, And if the sessions court accepts your surrender, you are taken into custody, technical custody, and then
Yes.
your regular bail can be considered.
Yes, ma'am.
You know?
Only there.
This is Ansari sir had written that judgment. That custody within the meaning of this 439 also means surrender to the.
Surrender, yes.
That window is there.
Yes.
Okay.
And in fact, without surrender on the day, my lord, he appeared before the.
Yes.
Yes.
Otherwise, magistrate will have to
Yes.
send him to custody. Disposal.
20.
Yes.
Is CD not received, my lord, in this case?
FI is at page 18, I am not on interim, madam.
IO is in election duty, my lord.
Yes, yes. Today is, of course, very difficult. So, I think CD will be necessary. Post office, some fraudulent activities.
So may kindly paste paragraph 5, 6 and 7 of my petition, my lord. I
5.
have 5, 6 and 7, my lord. I have already paid 10,23,000 rupees, my lord. I was put to suspension has been revoked, my lord. And there is no scope of, my lord, me absconding, my lord.
So 15, a lot of money, the CD will be necessary.
My lord.
Case diary is not received, issue reminder for the same. Full stop, a reminder for the same. Case diary, PS number, so and so on. Dibrugarh PS 40 of 26. List on.
On, my lord, 4th of May.
But can be little early, my lord.
Yes, yes, sorry, on 24/4.
Much of
Interim 9, no.
19.
No interim.
24/4.
Much of the.
एक मिनट दोनों सब हो गए एडमिशन कितना से हाँ फाइल नंबर टाइमिंग है सही बेटा हो ऑलमोस्ट ये ना चलो কোন কেটা হল এটো আছে এটো 37 38 39 এই গরু কথা এমনি জুনে আছে মাটি নহলে আমি
37, 38.
Matter worship, my lord.
CD.
My lord, first item is, my lord, BA number 557, my lord. In custody for last, my lord, 64 days. Now the case is, my lord, informant is my own sister, my lord. The allegation is that, my lord, we have killed our mother. This is the allegation, very serious allegation, the unfortunate thing, my lord.
sister has alleged that brother has killed
Yes,
brother.
yes, yes. Very minor, unfortunately, if it is so, my lord, subject to. Now you will kindly see what happened. Actually, she is 65 years old. And for some, quite a few months, she is suffering from depression because nobody was taking care except the petitioner, my lord. And ultimately, my lord, she was found in a house, in a club, in a hanging position, nearby house, my lord. And thereafter, my lord, this petitioner number 1, who is an advocate by profession, my lord, he has gone there and he, without calling the police, my lord, immediately come and immediately he taken her to hospital. On the way, she died, my lord. So now kindly say page 30. Please 30. 4-person named, my lord, number 1 and 2 accused are present petitioners who are in custody. Other petition, my lord, they are the wives of both the persons, my lord.
Okay.
Yes. Complainant respectively submit that the above mentioned accused are my real brothers and my sister, respective sister-in-law. It is mentioned that my mother, namely so-and-so 65 years, who is also a mother and mother-in-law of the accused person respectively. The above accused have been physically and mentally torturing my mother for 7-8 years. The accused have stopped the complainant and the complainant's elder sister so-and-so visiting her mother at the accused house. It is very sad to inform that 5 months ago, my mother's leg was broken and she was undergoing treatment. And in this regard, when two sisters came to visit her, the above accused had beaten both of us and threw out from their house and further asked not to visit in future. The real fact is that my mother inherited property, ultimately property, my mother inherited property from her father, and my mother's brothers gave 1 lakh, 1 kata 5 lakhs of the land to my mother. The above accused pressured my mother to sell the property received through the inheritance for about so and so. But my mother says that there are 2 more daughters, and if I sell property, I will give it to all the children equally. The accused were angry with my mother and were physically and mentally torturing. On last Sunset around 9 p.m., the accused applied severe mental pressure and argued with my mother to seek her share of mother. How she came to know, she lives far away, my lord. Finally, on 2 at around hours, the accused premeditated killed my mother and hang her for the ceiling fence I saw in the club. So now only medical report will say, my lord, whether any injury or anything is there, or it is going to say the matter. Only ultimately property matter. Even suppose, my lord, even after death also they are entitled to get it under the my lord, inheritance law, my lord. During the my lord, lifetime, nobody can get the share of the living person.
But I think there's a provision in, I don't know, it is in Hindu Succession Act.
Yes, that is another.
If a person murders his father, the whose property is that, he cannot inherit that property.
In
Right?
Islamic law also.
Yes.
So that this allegation is my only my lord, nothing because of that. I think my lord, I am not very unfortunate, my lord. I am not because
all kinds of
now
things for
64
property.
days, my lord, today.
Anyway, so
far
Is they received, PM report also received?
for the sister-in-laws.
Sisters, the wives of item number 36. 36.
Husband, item number, 21, and both wives, in item number 20.
No, 29. 37.
37, and her husband, wives, 38.
38.
And here postmortem report received. As per postmortem report, death was due to asphyxia resulting from antemortem suicidal hanging. But there are statement of witnesses, your lordship. There are several witnesses, and before the incident, the witnesses suspected because they stated their statement that already the one leg of the victim deceased already was broken, without
Broken, so some accident.
Yes.
yes. And at that point of time, without the help of a cane, she cannot even move around. So how, my lord, in the incident occurred in a clubhouse, which is situated in front of the house of the present petitioners, my lord. And so how she can, the height of that clubhouse is above 3 feet. So how she can, my lord, go to that place, and thereafter, my lord, the rope which is there in the ceiling of that house, she, my lord, committed suicide. The statement of the witnesses regarding that aspect. And for last 7 and 8 years, these accused persons, my lord, continuously, my lord, harass the victim deceased regarding that aspect. There are statement of the witnesses, my lord. And even sometimes beaten also, my lord.
Part dictation.
Otherwise, postmortem report states that, my lord, case of
Part dictation.
Full evidence and medical evidence.
I'll see probably. Sit down. The senior counsel, Vishal Chaudhary. The 2 petitioners here who are the brothers of the informant, seeking regular bail in connection with Howley PS case 9 of 26. They were arrested on 3/2/2026. The informant is the sister of the daughter of the deceased, and she lodged an FIR on 2/2/2026 with the allegation naming the present petitioners, within bracket her brothers, and two of her sister-in-laws. Full stop. She alleged, the gist of the allegations is that her mother had inherited some property after the demise of her father, and also she had got some property from her brothers, and she wanted to distribute the property equally, but petitioners have been pressurizing her to give the property only to her, and with regard to the same have been inflicted torture upon her for several years. it is further alleged that on 2/2/2026 in the morning, they killed her and hanged her from the ceiling of one club located in front of her house. The learned senior counsel submits that they have been in detention since their arrest, ever since their arrest on 2/2/2026. Full stop. The learned additional PP submits that the postmortem report, though the postmortem report indicates ante-mortem suicidal hanging, but it is revealed by the investigation that the deceased had suffered a fracture and was walking with a stick, and how it was possible for her to indulge in suicidal hanging, and that too in a place which is located in front of their house. It is submitted that the statement the witnesses examined have stated about the victim being subjected to continual harassment and torture by the accused persons over such property issue. The petitioners are the sister-in-law and wife of accused number 1 and 2. Case diary, kindly give me the case.
Yes.
Chamber, I'll go through it once. Duta chamber.
Right, Your Lordship.
Yes, this is all clear. So,
My lord, before starting my senior colleague, my lord, here, Lordship may kindly page the office note 7/4, my lord.
not received.
My lord, although scan copy received, but affidavit status report not received, my lord. In the second para, my lord. Status report,
Status report.
my lord. In the last occasion, this is called for, my lord.
Last day,
61 days. So what should we do? Should we postpone it?
261 days today.
It's a case of
Yes, huh?
whom is that?
My lord. They entered into the house of with deadly weapons, my lord, and assaulted all
Deputy,
the
my lord,
victims,
and Your
my lord,
Lordship already,
and taken rupees, my lord, 1,50,000.
nobody named 5% only got my lord bail, my lord, out of 10.
Anyway,
2 persons,
let us get the
My lord, up to date status, my lord.
my lord, timing is.
Mr. Just a few days. Just, Mr. B. Sharma.
I let Your Lordship.
Draws attention to the office note dated 7/4/2026 and submits that the status report and the connected documents mentioned in the order dated 19/3/26 have not yet been received, though other parts of the scan record is available. Issue reminder for the status report of the trial and scan copy of charge order and deposition statement. List after on that week list.
Position, my lord, charge not framed, my lord.
Charge not framed.
So the position question only, my lord, Your Lordship.
No charge, no charge.
Charge sheet file, charge not framed.
Oh, then.
So
After this,
Status report will do.
after status.
Date one, my lord, Your Lordship.
Status report will do.
My
23?
my lord.
23. Obliged to.
40.
I was arrested, my lord, on October 1, 2025, my lord. Today, 188 days. Already, my lord, 5 number of witnesses, including informant and victims, are examined, my lord. Kindly come to page number 18, my lord, FIR. May I read, my lord?
No, I remember the FIR broadly.
Now, my lord, then,
But how many witnesses have been examined? So far?
my lord, 4 witnesses, my lord, 5 witnesses are examined.
Out of? Are you in a position to say that? Let us check.
Yes.
Charge sheet is here.
My lord, their evidences are full of contradictions, and my lord, introductions of completely new facts, my lord. They fail to identify exactly who is this Rani, who the Rani is, my lord. And my lord,
The victims have been examined.
examined, my lord. Both of them are examined, my lord. Informant was fully, he was also examined, my lord.
Informant and victim examined.
Examined.
Total witness কিমান আছে?
8, 9, 10. Listed witness, my lord, 10. And my lord, two other witnesses are important who issued, my lord, transfer certificate. They will also be examined, my lord.
There are 3 accused persons now.
And accused number 3, my lord, jury does.
In this kind of cases, the police should always, investigate and bring materials about dual name,
Yes.
about identity.
Your lordship, my kindly regarding identity that I'd like to point out. Page
Suppose
20.
I have a pet name. Suppose you also maybe have a home name.
Yes.
Home name. Suppose we
Home
have.
name.
No, there will be someone who will give evidence regarding that.
Yes.
That name of ours may not be in the records,
Right.
but some of our family members may say that. So some evidence should be brought.
Your lordship may kindly come to page 28. I will point out, my lord, regarding that.
Page 20.
Page 28 of the petition, my lord, that is searched investigation details, and Rani is the her true identity as jury does. I will point out, my lord. Page 28, investigation details, my lord, your lordship, paragraph 3. Second line, my lord. On interrogation, she revealed her true identity as jury does. My lord, from the first line, my lord, efforts were made to apprehend the hotel owner Shamim Ahmed and the woman identified as Rani. After sustained investigation, the woman was traced and apprehended. On interrogation, she revealed her true identity as Zuri Das, wife of Sud.
This has to also come in the trial evidence.
Trial, yes.
It can come from the testimony of IO also,
IO.
but it has to come in the trial also.
Trial also, yes.
And therefore, and if and the name spec should be thrashed out ideally at the stage of framing charge only. So what you frame charge against A, B, alias C.
Yes.
You give the alias, then it's okay.
Yes, Your Lordship, but if I may add, in the deposition by the victim, she has identified
The person,
the
Jury
person,
does
yes.
as the person.
Yes.
In the doc. That's okay.
And my lord, in their deposition, my lord, one of them said they made Rani.
And detailed search framing order is also there. They have not disputed their identity, my lord, at any point.
Anyway, so
She has not disputed there.
thing is that these alleged offences are very serious because
Yes, very serious.
they were subjected to POCSO has come also. No?
Yes,
POCSO
yes,
covers.
well, search frame under section 6 of the POSCO Act.
Multiple, the assaults, they are minors.
Yes.
They were trafficked, elements of trafficking is there. So that way very serious. On the other side, from the point of view of the accused, the trial is halfway through.
Yes.
And victim informant have been examined. So
Okay.
now should we grant them bail or should we not? That's the thing.
Section 6 of the POSCO Act, section.
They are in custody since?
My lord, 1/10/2025. Today is 189 days, my lord.
She is actually the main supplier, man. Other two accused person is one of the owner of the hotel and one is the manager of the hotel. She in connivance of the, my lord, she in fact, my lord, directly in touch with those, my lord, victimized girls, my lord. And thereafter she lured them to provide them job, and thereafter taking all those, my lord, victimized girls to the hotel of the present accused number 1 and 2. And thereafter she not only, my lord, use them in that particular hotel, but there are evidences, see, my lord, thereafter, my lord.
But my lord, in their evidences, they clearly stated that they met Rani for the first time. And my lord, they said, one of them said,
In the
my lord,
railway station. In the
railway station. They are in their earlier statement, they said they met Rani at Kamakya station. In evidences, my lord, they said, my lord, at Gauhati railway station. One of them said, my lord, at 5:30 p.m. One of them said, my lord, at 12 noon. One of them said, my lord, Rani is a younger girl, my lord, Swali. And another said, my lord, she is a, my lord, woman. So, my lord, this is very confusing.
Because
Exactly
both the
who is
girls
Rani.
are from BTC area, I think.
Yes.
My lord, I may be draw honorable court's kind attention to an important fact, my lord. Here, my lord, immoral traffic act is there. Sections of immoral traffic acts are there. But, my lord, investigation was done by a unauthorized person, my lord. Sub-inspector on probation, my lord.
Those aspects will come in trial, and
Yes, my lord.
if it is supposed vitiated, then the immoral traffic
Yes,
will
ma'am.
go.
Yes.
But the others will
Other
remain.
offenses. And if he is sub-inspector, my lord, that is, my lord, he has the.
He's not qualified to investigate.
No, my lord,
Immoral
sub-inspector has the
traffic.
My lord,
sub-inspector has
section
the power.
13, my lord, he cannot investigate.
DSP.
Sub-inspector.
Section 13. Special officer shall not be below the rank of
Regarding
inspector of
that
police,
aspect,
my
my lord,
lord.
whether that
Inspector.
special authority is there or not, that will come.
My lord, in their
During-
charge sheet, my lord, clearly says that he is a sub-inspector on probation.
Anyway, so
Probably on
This
being
is also, my
authorized
lord,
for that
important.
particular.
anything from your side?
No, Your Lordship, I'll just concur with the submissions made by the learned people, Your Lordship. And also it's a crime against society, Your Lordship. So at this stage, Your Lordship, yes.
Okrajan.
And moreover, the victims have already identified, and they have been, more or less, they have been consistent, Your Lordship, their statement. And these are minor discrepancies probably in the timing and the place, Kamakya station, Gauhati railway station, these are minor.
Sit down. R. Sharma, Land Counsel for the petitioner, and P. Bhattakur, a learned additional PP, and M.K. Brown, learned amicus, appearing for the informant first. Invoking 483 BNSS, the petitioner Juridas is seeking regular bail in connection with special case number, special POCSO case number
217, my lord. 217 of 2025.
arising out of Gorsuk case number 269 of 25. Under sections so and so, so and so. He was arrested on 1/10/2025. The gist of the allegations, the allegations against the petitioner is about involving in trafficking of minor girls and forcing them into prostitution at a hotel in Gauhati. The victims are stated to be from villages in the district of Kokrajhar. Full stop. It is submitted by the learned counsel that the testimony that so far out of 10 listed witnesses, 5 witnesses have been examined, including the victim and the informant, and that the testimonies suffer from contradictions. Full stop. It is also submitted about the length of detention. On the other hand, the learned additional PP submits that the testimony of the victims have been cogent, including in the aspect of identification, and that the alleged offences are of a very serious nature. Full stop. Ms. Brown, learned amicus, supporting the submissions of the prosecution, further submits that the alleged offences are heinous in nature and against society, Full stop. I've gone through the relevant portions of the report which is available for the purpose of adjudication of this bail. The victims are stated to be aged 16 and 17 years. Full stop. It is revealed from the materials that they were lured, they got lured with the prospect of being given some job and then found themselves being forced into prostitution. Full stop. The alleged offences involved the alleged offences pertain to trafficking under the Indian Penal Code, semicolon, penetrative sexual assault, repeated penetrative sexual assaults under Section 6 of the POCSO Act, and also provisions of the Immoral Traffic Act. In this context, the learned petitioner counsel submits that the investigation was done by SI, though as per the Immoral Traffic Act, it is required to be done by an inspector first. That aspect would be a matter of trial. However, full stop. Alleged offences of human trafficking, full stop, child sexual abuse, and forcing children into prostitution is a very serious matter. And despite the length of detention, as the trial is still in progress, I am of the considered view that it would be prudent not to grant bail at this stage. In such view of the matter, the bail petition stands rejected at this stage, disposed of accordingly.
My lord, date of birth is completely doubtful, my lord.
Okay, well, that is a matter of trial. In prima facie matter. You cannot prejudge. Let's go over site of number. You there? So,
Admission.
no. No, AB. Yes, again, 4 again. Bus. 41. Orders equal. Orders to the assembly. Okay, cool.
Item 22.
Okay. So. You have an answer, right?
22, my lord, as per office note dated 7/3/26, service report available.
Service insufficient address. As per office note dated 6/4/2026, notice upon R2 returned due to insufficient address. Fresh steps.
Yes.
The petitioner shall take fresh steps upon the correct address of the respondent 2. Interim order passed earlier shall continue in the next date of listing. List after the view holidays on a date to be fixed by registry.
23.
Your matter.
Yes, this service is complete, my lordship.
For someone is one order dated 13/2/26, second page of the record.
You have appeared, madam? You have appeared?
Lordship, I am appearing on behalf of the respondent number two.
Two, yes. So what do you say?
Yes, ma'am. Service completed, ma'am. That is the order is there.
Service is
Order dated 13/2/26.
The learned counsel, the petitioner as well as the respondent number two are presented by respective learned counsels.
Copy of criminal petition may be
Yes.
so pronounced.
The copy of the petition shall be furnished to the learned counsel for respondent number two. Full stop.
Lordship,
Scan order is TCR has been received? Has not been received? Yes.
Lordship, prior to fix the matter for admission.
Yeah, it is in, it's not orders. It's not been admitted.
The scan TCR received, ma'am.
Mhm.
TCR received, ma'am.
Yeah, it is there.
23.
This note is not updated. Scan report has been received in the meantime. Full stop. The interim order shall continue to the next date of listing. List in the admission column on. Should I fix a date or first week of May you take?
After 2 weeks only.
No, after April.
3 May, my lord, on 19th of May, my lord.
It's not late. It's okay. 19/5.
24. Much obliged.
Yes.
Actually, have a look at office notes dated 6/4. Steps are taken by with postal lordship. TCR has come here also. No, consistent forward, consistent. Presumption may be drawn your lordship because there are two other cases also against the same respondent. In those cases also they are not appearing your lordship.
Scan TCR has been received. However, as per office note dated 6/4, neither AD card nor unserved notice received in respect of the sole respondent. The registry may verify the postal tracking regarding such service if any. Then they'll verify and put up an office note. So list after the vacation on a date to be fixed by registry. Interim order shall continue till the next date of this.
Lordship, the interim may continue until this disposal of the material, lordship.
Don't know actually. Till the next date, then we can extend it if necessary.
Because every time.
Yes, that's true. Till further orders to the contrary. Till further orders to the contrary.
25.
Yes, madam. Here. I yes, come on.
Objecting to the grant of bail to the petitioner, your lordship, I have filed the
No, no, what is the IA for?
IA for objection, your lordship. Objection for granting bail to the bail petition.
Oh, sorry, AB is there.
AB, your lordship. AB.
She has filed objection.
That's what. Oh.
Your lordship.
And I have filed the opposition, affidavit in opposition also.
You can file an objection
But
here also.
in the postmortem report, the cause of death is kept pending, your lordship.
I have also.
So FSL report.
Case diary noted received.
FSL report may come, your lordship.
You are objecting, any interim order granted?
No.
You are objecting to
But-
grant of bail, final bail. Well, let him get the case there, along with PM report.
Matter may come up for bail hearing, my lord, already.
Right.
My lord,
Your lordship,
immediately
FSL
after,
report also may come, your lordship.
then my lord, immediately after vacation,
The
on the reopening.
IA has been filed by the informant objecting to the grant of bail, objecting to any object, has been filed by the informant by way of an objection in AB
In IA.
2026. Full stop. The case diary, AB, the case diary is called for is not received. Issue reminder for the case diary along with
FSL report.
PM report and FSL report. Yes. PM and FSL. Huh?
FSL report, postmortem report, your lordship.
FSL.
Postmortem.
FSL.
As well as FSL report, your lordship.
Postmortem PM and FSL report. List the matter in the column of bail hearing.
On 20th, reopening.
Any reopening on 20.
There is no interim, that's why, my lord, I insist.
Huh?
28 from.
28-4 is okay for you? Or
My
you
lord,
want?
20 or 21st, my lord.
Wait,
No,
I'll go to
21st,
matter
my lord,
six.
I am notice.
Huh? Yeah. What is the
There's a
date
problem.
convenient for you?
22 then.
24?
Oh, yes, 24 from.
24.
Obliged, my lord.
Obliged.
24, 4.
24.
26.
Yes, please, the lordship. Lordship, there is a revision petition, my lord. There is a delay. I have this file, my lord, for delay of 20 days, my lord.
Revision against?
Against, my lord, the appellate court has dismissed our appeal, my lord.
Concurrent
Appeal against
findings of-
acquittal. Appeal against acquittal, my lord.
Appeal against acquittal.
Acquittal.
Okay, then we'll have to notice.
Yes, notice has to go, my lord.
It's come up first day today.
Yes, my lord, it is first day.
The instant interlocutory application is by way of an application under Section 5 of the Limitation Act 1963, seeking condonation of delay of 20 days in preferring a criminal division against the judgment of acquittal passed by the appellate court in criminal appeal number appellate court at Gauhati in criminal appeal number 7 of 2023. Issue notice upon the respondents, respond number 228 within bracket the acquitted persons. Steps of notice by speed post.
I'm the play order.
List the matter after holidays, after due holidays on a date to be fixed by registry.
My lord. Obliged.
27.
The civil matter.
Let me be, lordship, there is right clerical mistake, lordship, in the order of date of local passed by your lordship, lordship. So that is to be corrected.
Just a moment.
That's this
Enter order.
2 lakhs amount.
Oh,
In
I see.
whose name it will be fixed.
I made a mistake, sorry. Okay, what is to be corrected?
That 10 lakhs, that may kindly be kept fixed debate in the name of this one number 2, 3 and 4.
We will correct it. We'll correct it.
And lordship, the rest of the amount may kindly be released to the claimant number 1 claimant.
Okay, that was left out.
That is also
In the
left
order.
out, to whom it is to be released.
For it, no, side.
I'll fixed dividends should be divided among the 4.
Anyone for the other side? I'll pass it, I'll go through it and pass correct.
Okay, lordship. Because it's before the view, during the view, they can withdraw the amount. It is already.
No problem.
Yeah.
I'll do it right away.
The MSc appeal, madam, if you are submitting, we are not a party.
Hmm?
This is MSc appeal, we are not a party.
No, yeah, I know. Suddenly it came actually, because it's my order. Criminal petition. Mr. Samoa, yeah, these are admission orders.
Yes, madam,
Just
item 11, my lord. I'm a legal aid counsel in this
we
matter.
can just admit it then.
My
It's
lord.
for admission only.
Yes, admission only. And my lord, there is a prayer, my lord, for suspension of sentence.
But that has to be heard, no?
Well, the RI is for 3 years.
No, that.
And I have already
11
spent.
is for admission only admission.
And there is an I along it, my lord.
It's not showing the cause list.
But the records are there. I is there.
Otherwise, 12 is also yours?
No, 11 is mine.
Oh, in that case, we have to hear them.
Yes, I am for
12 is
12.
12. We'll hear it after lunch.
There is a IA also for suspension, then POCSO there is notice.
Notice has to be.
Yes, my lord. There
Issued
is
notice.
POCSO, my lord.
I thought just admission and
Yes, ma'am.
do it and make you free.
My lord, yes, my lord. At 2 p.m. actually there is another matter fixed in a different court. Lord,
No, and today actually many people have to leave also. Even
Even
2 members of my team, they have to leave for Bongaigaon. Anyway, but we will do the work.
my lord,
We have
in
to keep it.
item 11, my lord, there is an IA for suspension
Suspension
of
of
sentence.
sentence.
The RI, the punishment is for 3 years RI. I have already spent more than 1 year, 5 months.
I see.
But I believe, my lord, this much is enough to release him.
I'll pass the order.
Yes,
to
yes.
September.
Yes, I'm a legal aid counsel for
I
it.
have to hear.
It's not.
It's not shown, but it is
That's
there.
why I got confused. I
It is
not
there on the records.
I is not shown, but can we pass order if it's not listed?
If that is
No.
there in the record, my lord, then, but otherwise when the cause list. my lord,
Cause list not showing, but record is there, my lord. I have checked.
I'll see it. Your submission I have to take after at 2.
Yes.
At 2.
3 years, my lord, or if already he is in previous bill, but other. only
Not
for-
previous bail, I'm in jail.
1 year is passed already.
More than 1.5.
Maybe I think maybe
Oh,
justified.
yes.
Otherwise, if it gets delayed,
Yes.
then we do not know what is the merit of the appeal.
But
So we'll
only
see.
if my lord record is there, then.
We'll see. Without detail.
Otherwise-
Well, he deserves a bail, my lord.
And 12 is that we have to hear.
Yes, my lord.
Notice is not complete.
No, my lord. This is first time, my lord.
Oh, little deduction. I'll make you free.
Well, I'm deeply obliged. Very kind of your lordship.
No, it's okay. It's my duty. I understand.
May I leave, my lord?
Yeah.
I'm deeply obliged.
It is for 5 years, my lord, rigorous imprisonment.
Notice has to be issued.
Yes, my lord.
Let us admit the criminal appeal.
Yes, my lord.
Instant criminal appeal. Okay. Third, against judgment and order 10/2/26 passed by learned special judge POCSO Gauhati in special POCSO 23 of 2026, convicting the person under section 75(1) BNS read with 10 POCSO Act, sentenced to undergo short liquidating. Full stop. He's in custody.
Yes, my lord.
The appellant is stated to be in custody. Full stop. Admit the appeal. Call for the original PCR of so and so. Issue notice upon the respond number 2/inform through speed post. To the office of the
My lord, public
prosecutor
my lord,
and to be executed through the concerned police station. Full stop. The IA is for suspension of sentence by the order dated so and so. Full stop. The main appeal has been admitted today. Full stop. Issue notice upon the respond number 2. Release the matter when? Date?
Yes,
Or
my
after
lord,
the
May,
vacation?
in the May.
In the month of what is the sentence? 5 years.
5 years,
In the month
already
of-
9 months, 30 days.
In the month of May, on a date to be fixed by registry. If it gets late, you make a mention.
Yes, my lord.
12. Okay. What else? Anything else?
Your lordship, in regards to item number 28, your lordship.
Just a
the-
minute, just a minute, ma'am. 8, 9. It is 10. 10 to 100, no?
28.
Just a minute.
Infractions.
11, 12. Get our roll.
Hearing matter, my lord.
Which matter?
28, your lordship. In the
28.
Yes, lordship.
What is 28? Oh, that's a hearing matter.
Hearing.
The matter has been become infractious, your lordship.
I see. Okay, is it, what kind of matter? Anyway, should we, because I have to see the file.
My lord.
You are for the respondent.
Yes, lordship. My lord, may kindly peruse the last orders. The petitioner is not appearing before the court. And
It's a
on
very
the
old
last.
matter also.
Yes, lordship. They have settled.
Your case, Sarma?
Yes, lordship.
Yes,
you shall.
Maintenance matter.
Yes, lordship.
Yes, someone. You know?
I just want to know and what sense it has become infractious.
Your lordship,
Because I mean, just
yes, lordship.
because maintenance matter,
Yes.
should we wait for them after the vacation?
No, your lordship, because as per my client's instruction, they have amicably settled the matter and a lump sum amount alimony has been given to the opposite party, which is the wife.
None appears for the petitioner on call. I find from the record that on the last 2 dates as well, that is 26/3/26 and 10/6/23, 26 also, none had appeared on behalf of the petition. Ms. K. Sharma, learned counsel, appearing for the sole respondent.
Yes, lordship.
Sole respondent submits that this petition has perhaps become infractious as both the parties have amicably settled the matter and the petitioner has paid a lump sum maintenance to the respondent who has accepted the same,
Yes,
right? This one. Then what should we do? Should we, on this basis, will it be okay? to
Yes, Lordship.
Close it.
Close it. Lordship.
It is submitted by the learned counsel, Ms. Sharma, that she has definite instructions regarding the same, and that the matter can be disposed of upon settlement. So I can record.
Yes, Lordship.
In view of the same, it's all matter. So in view of the same, accepting the said prayer of the respondent side, the revision is disposed of as having become infructuous and upon settlement between the parties.
Yes, Lordship.
My lord, here one submission, my lord, in item number 14, my lord.
1/4.
1/4, my lord, there is a submission, my lord, that PPS submitted fairly submitted. Perhaps that line may not be referred, my lord. Only my objection is that it is commercial quantity 12.
I will delete.
My lord, that is
I will delete.
that line, my lord.
So what is remaining then?
Remaining, my lord, 41 item number 41 remains, my lord.
And seven, item 7.
Item 7.
PS law also, my lord, today, my lord, PS. Yeah, again, part PS law also.
You have for the. Should we do it today or after the election?
Lordship, Engaged Council JC Gaur will conduct the matter today.
You want to do it?
Well, Lordship, we fix it some other day, my lord, because PS law who was appeared.
Lordship, he's
So he has also some difficulty today, my lord.
PS law is for respondent.
No, my lord.
He's for the state lordship.
At the time of when part third matter, my lord.
Oh, sure.
On that day,
Okay.
he was there.
I see. Yes. Additional PP.
Yes.
Lordship, state's existence is not only required in this matter only because the final report was submitted only.
Okay, I'll see.
Last date it was part third, Lordship.
And what else?
And his name also not reflected that he may be.
If my lord, state is a formal party, then my lord.
Then we'll see.
Lordship, may kindly see it too because JC Gaur will conduct
Okay,
it.
I will see that too. Not closing. Because some of my team has to leave also today, and one of them is there. She'll be there.
Your lordship may fix any other convenient
Just
way. my
let me
lord.
see. I'll see it once and two and take a decision. We'll literally take a decision.
Yes.
If we find inconvenience, because then it's okay, no problem. 27 is there. So 41 is left. 41. No other matter.
41.
Hmm? 7 and 10 kuntal. He was here. Yes, sir. Okay. Okay. So we cannot call for case diary also. Otherwise, I have call for case diary. None appears on call. List the matter after the view holidays on a date to be fixed by registry. We'll mention it if necessary.
41.
May I please, I'm sorry, in the first up, we are not there.
No.
Right, here, my lord, regular bail application, my lord, the accused petition. He is in custody, my lord, from 6/3, that is around, my lord, 34, 35 days, my lord. Yeah, my lord, the sections which has been attributed, my lord, have been attributed. There is, my lord, 189(2), that is available, my lord. 296 also available. One section or 118(2), my lord. That is non-valuable, my lord, grievous hurt, but that has to be possibly with sharp open, my lord. Yeah, my lord, can you have a look at page 11, the FIR, my lord? The FIR reflects that, my lord, the whole incident, my lord, they have added one line, my lord, that last para, they attacked him with fists, kicks, and by a sharp weapon. They have alleged, my lord. Now, our case is that, my lord, the petitioner accused before lordship, my lord, he has a nearby shop, my lord, bookstore, my lord. So he was there, and it was the evening of Holi, my lord. So, my lord, what happened, my lord? There were three, four other person. There was an altercation with them only, my lord. So the present accused being a resident and he was present there. He, my lord, also was, he came out to saw what happened, my lord, commotion and all. And my lord, thereafter on the next day, he was called to the police station. Now here, my lord, possibly we need to see whether, my lord, on the merit, my lord, any sharp weapon was used or not, my lord. And our case, my lord, no sharp weapon was used, my lord. I was not at all, my lord, involved in that, my lord, whole incident, my lord. Maybe I would have been a witness to the whole occurrence. Only because they know me, my lord, I have that shop, my lord. They have stated in the FIR that, however, out of those accused is Deep Sarkar. That one of the accused is Deep Sarkar, my lord. Rest, my lord, my colleague, my lord, he would say whether, my lord, any sharp weapon was used, my lord. And he is custody for around 34-35 days, whether, my lord, further detention is necessary or not, my lord.
My lord, here we have received the case there, my lord. The medical report also there, my lord. And lordship, statement of the victim, my lord. And two other witnesses, my lord, who was eyewitnesses, my lord. They have seen
Altercation and
my lord, assault.
fracture of left orbital floor. Fracture here.
My lord.
Fracture of nasal bone. No, badly assaulted. Subconjunctival hemorrhage. Fracture of nasal bone also.
My only thing what I prayed, my lord,
Grievous injury.
whether because grievous injury as such, my lord, it will be offense under, my lord, 117(2). With all respect, my lord.
My lord, victim statement, lordship, victim statement and two eyewitnesses. They have identified the present petitioner.
Strongly question.
My lord.
But here, on the, my lord, technical aspect, my lord, kindly see whether, my lord, I am insisting, my lord, whether any sharp weapon were used, my lord.
They have hit, but injuries are fracture injuries.
I understood, my lord.
Usually, fracture injuries are usually caused by blunt weapon.
Exactly, my lord.
Blunt weapon.
Exactly.
Otherwise,
And
cut injuries will be there.
Exactly.
Unless it is hit from the other side.
Absolutely, my lord.
But
Because
still, it's a fracture of the orbital means.
that is true, my lord. But
near the eye.
My lord.
My lord, 117(2), my lord. Should I read it or not?
No, you can
Yes,
read
my lord, because my lord, at best or at worst, it will be a case of 117(2), my lord. Alia 325, which is a bailable offense. And it is not a 430 anticipatory bail application, or regular bail, around 34 days in custody. And technically also 118(2) is not made out, my lord. And no possibly weapon of assault ever used. That's why neither seized also, not seized, my lord. And it was a fist fight, my lord. That too, where I was not there. Definitely, if some evidence or witnesses are there, my lord, I'm not going into that, my lord. Fist fight, and they have only insider and a sharp weapon. I think that, my lord, the length of detention and because injury report, whether it says by sharp weapon, possibly not, my lord, because it was never used, my lord.
I don't know, it is said they were not yet recovered, my lord. That's
true.
My lord, that is.
No, medical report, it has to be whether not only that grievous, if it is grievous injury, then, my lord, caused by what weapon, my lord? That is the most paramount, my lord, with all respect, my lord. 34 days, my lord, lordship, kindly let him go, my
Because the
lord.
injuries are a bit serious.
That is true, my lord. That is
Eye and nose. Anyway.
Tomorrow is voting day also. If he comes out, my lord, he can vote also.
A. Chaudhary, Learned Counsel petition. Invoking 483, the petitioner is seeking regular bail in connection with Bhorlamukh PS case number so and so. He was arrested on 6/2/2026. The allegation in the FIR dated 4/3/2026 is that page 23 marked portion, you can write. Page 23 marks with full stop. The case diary as called for has been received. Full stop. The medical report indicates grievous injuries in the nature of fracture near orbital floor and near nasal bone. Full stop. The learned additional PP submits that the eyewitnesses have stated about the assault. Full stop. Though the witnesses have also stated about assault with sharp weapon, but the IO has stated that so far the sharp weapon has not yet been recovered. From the nature of the injuries, it appears that assault was by a blunt weapon. Stop. I've seen the progress of investigation. Full stop. Full stop. The medical report has been collected and statements of several witnesses have been examined. Despite the incriminating materials, considering the length of detention and the progress of investigation, the accused is allowed to go on bail of rupees 50,000, one severity of the like to the satisfaction of the concerned learned court, CJM Kamrup Metro, and subject to the conditions that she shall cooperate with remaining investigation, shall not hamper on temper, and he shall not in any manner cause any harm or harassment to the informant/victim. Violation of bail conditions will entail cancellation of bail. Return the case there.
Much obliged, my lord. Highly obliged.
Next.
May please. My lord, this is an application for passing, my lord. On last occasion, lordship desired, my lord, some clarification regarding, my lord, the copyright act, my lord. My lord, there is a judgment of Honorable Supreme Court, my lord. I'll call this. My lord, regarding jurisdiction, my lord, under copyright act, my lord, in case of, my lord, the books or, my lord, relating to, my lord, films or, my lord, the songs, the court where, my lord, the books or the articles are sold or where, my lord, the films or the songs are, my lord, exhibited, that court had the jurisdiction, no doubt, my lord. But so far this case is concerned, my lord, para 13 of this. May I just have a look at para 13, my lord.
There are 13 of this judgment.
My lord. May I read, my lord? The principle governing summoning of an accused in a criminal case as well as parameters for quashing criminal proceeding are well settled. Summoning of an accused in a criminal case is a serious matter and criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegation in the complaint to have the criminal law set into motion. The order of magistrate summoning the accused must reflect application of mind to the facts of the case and the law applicable thereto. The magistrate must carefully scrutinize the evidence brought on record and determine whether any offence is prima facie made out. The magistrate may even himself put questions to the complainant and his witnesses to elicit answers to find out the truthfulness of the allegation or otherwise, and then examine if any offence is prima facie committed by all or any of the accused. 14. When an accused seeks quashing of either the FIR or criminal proceeding on the ground that such proceedings are manifestly frivolous, vexatious, or malicious, the court is duty bound to examine the matter with greater care. It will not be just enough for the court to look into the averments made in the FIR or complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the offence are disclosed or not. In frivolous or vexatious proceeding, the court owes a duty to look into many other attending circumstances emerging from the record of the case, over and above the averments, and if need be, with due care and circumspection, and try to read in between the lines. The court, while exercising its jurisdiction under Article 482 of the Code or Article 226 of the Constitution, need not restrict itself only to the stage of a case but is empowered to take into account the overall circumstances leading to the initiation or registration of the case as well as the materials collected in the course of investigation. Now, my lord, so far the present case is concerned, my lord. Admittedly, my lord, it is a private complaint, my lord. Now, my lord, prior to filing this complaint, my lord, the complainant has lodged an FIR, my lord. May I read, my lord, that FIR?
Yes.
It starts from page 38, my lord.
We have gone through it already. I think.
My lord.
We have read this FIR.
Yes, yes.
No,
So,
my lord, no need to repeat. This ended in final report, then the complaint.
My lord, my lord. Now, my lord, just have, my lord, just see, my lord, that in FIR also, my lord, the allegation is that, my lord, in the year 2019, my lord, this informant complaint came to know that, my lord, I am manufacturing such and such articles from such and such machine, my lord. And admittedly, my lord, my machine is installed in the state of Rajasthan at Dholpur, my lord, in a industrial area, my lord. And my lord, I'm just taking your lordship to my lord, so, one more judgment of my lord, that is part of this record, my lord. My lord,
The other side has not appeared.
No, my lord, they didn't. No. My lord, first in their 2016, my lord, they lodged similar FIR, my lord, in the.
No, I'm not going to that. They are not appeared.
No, my lord.
They have not appeared. No. The state is a formal party.
Yes.
Okay. Please go on. So the complaint was lodged and then. Yes. Go ahead. Go ahead. Continue.
Okay, my lord. So, my lord, if we look at the, my lord, this FIR and the complaint petition, my lord, the allegation is that in the year 2019, my lord, the informant complainant came to know that I have installed the machinery of their, my lord, design, and I am manufacturing their product, my lord, that the hand gloves, etc.
That is that.
That is the allegation, my lord. Now, my lord, if this is the allegation that since 2009, in 2019, they came to know about, my lord, manufacturing, my lord, then, my lord, how this is patently false, my lord, just have a look at, my lord. Page 51, my lord. Page 51, my lord. It is a typed copy, my lord. It is also, my lord, in Varna, because, my lord, this FIR was lodged in Noida police station, my lord, sector 20. It is also there in the vernacular, it is also there, my lord. But I'm reading this typed copy, my lord, page 51, my lord, and except H. My lord, this FIR was lodged on 27/1/2016, my lord.
What happened to this case?
My lord, in this FIR also, my lord, my name is there, my lord. Page 51B, my lord.
It was this case resulted in final report. No.
Yes, it was also resulted in final report, my lord. Then they filed an objection, my lord, and on the basis of objection, my lord, the complaint case was registered. And we approached, my lord, Honorable Allahabad High Court, my lord, and the proceeding stayed, my lord. So, my lord, there is stand that in the year 2019 they came to know that is totally false, my lord. Because 2016 they lodged a similar FIR, my lord. And my name is there, my lord, in page 51B, my lord, Swear Healthcare. Here, my lord, they accused the director of Swear Healthcare Private Limited, my lord. The same company, my lord, having same address, my lord. And there, my lord, 2-3 employees of my company also, my lord, arraigned as accused, my lord. And those the persons who fabricated the machine, my lord, they were also arraigned. But the fact remains, my lord, that they know that I have installed this machine in their 2000 prior to 2016, my lord. So they cannot say, my lord, that since that proceeding was stayed in their started in 2016, my lord, and it was stayed in the year 2021, my lord. That order is, my lord, page 57. Order dated 17/9/2021, my lord. Next, that order of Honorable Allahabad High Court, my lord, is 57, my lord. So, my lord, after stay of this, my lord, proceeding, they initiated just to arrest the.
So the proceeding, this was initiated.
My lord. And apart from it, my lord, in the year, my lord, 2015, my lord, My lord may have just a look at my registration certificate, my lord. Next
Page.
page, my lord. Page 47, my lord. Page 47, annexure F, my lord. My lord, this is a certificate under value-added tax, my lord. Rajasthan value-added tax, my lord. And here my name is shown, my lord. This is to certificate the Swear Healthcare Private Limited. Now, my lord, the date with effect from 21st September 2015, my lord. So, my lord, and my lord, the materials what business I am doing, my lord, in around the middle, my lord, intend to sell latex, calcium carbonate, calcium nitrate, and plant and machinery latex surgical gloves. So surgical, here, my lord, the dispute is regarding surgical gloves. I mean, surgical gloves, my lord, I am manufacturing since 2015, my lord. I am manufacturing surgical gloves since 2015, my lord. 2015, also, my lord, they filed a civil suit against, money suit against me, my lord, on the same ground, my lord. And they obtained a ex parte decree, my lord. They obtained ex parte decree, my lord.
Anyway, so we are on this, so basically you think that the jurisdictional aspect apart, there is no merit.
There no merit, my lord.
That is, I have understood.
My lord, patently this is, my lord, a business rivalry case, my lord. They just want to establish. And regarding jurisdiction also, one more judgment I am relying 2000. It is reported in 2004, 8 SCC page, and that I am giving copy. And that is reason, my lord, they are not, in spite of service of notice, they are not, my lord, contesting the case. They know, my lord, it is a patently false case, my lord. And when they, my lord, they themselves lodged an FIR in 2016, my lord, against me and the other of my employees, how they can say, my lord, that I installed this machine in 2019, my lord?
Let's see. That's not true. I'll not dictate here. I'll reserve it because I'm some time constraint also. All of us have today. But so none appears on behalf of us. Would you like to say something?
Yes. Only just one aspect I would like to point.
I'll have to study the file. I'm not dictating here.
That intellectual property minus regarding violation for design and for violation of which now the point of jurisdiction has been raised.
No, as I've understood, sir has argued that the first jurisdiction, territorial jurisdiction. Second, on merits also it doesn't have a case. Secondly, it is just a just a malified case to harass.
Yes, their allegation is that, my lord, I am manufacturing from the same machine which they.
No, in the context of your submission regarding the stay of Allahabad High Court.
My lord.
That's right.
And that property, that machine is now installed at my lord Boku.
No, not my machine, my lord.
Which was violation of.
My lord,
that is the complainant.
That
is why the complainant tries to get contents about jurisdiction due to that Boko. If no part was in Assam, then of course.
Ultimately, violation, the intellectual property is installed at Boku.
No.
And for violation of which, my lord,
the complaint, my lord, assuming that the complainant has, my lord, any intellectual property right, my lord. In that case, my lord, he may have installed his at several places, my lord. The offense will be deemed to be committed where, my lord, the accused has installed the machine, my lord. It's not the complainant. He may have offices in other parts of the planet also, my lord. He may have in USA or any other place. But where the accused has the, my lord, installed the machine, that is the where the offense is committed, my lord. I have no installed the machine in Assam, my lord. I have no office in state of Assam, my lord. How I can say that how I can be said to have committed any offense here, my lord?
And their factory is also closed, my lord. They installed this machine only to get subsidy, my lord. Nobody is there in Boko.
Anything else from your side? No. Okay, nothing people like that. I'll go and conclude judgment reserve.
Obliged.
I don't know what the person. We have one more matter.
Yes.
Council is not there, shall we?
Next ten was there.
The other side is the CBI.
I am CBS.
No, no, it's okay.
May I please your honor?
Mentioned as PP assumption.
They have wrong, yes.
We'll observe next day, your name will be. Achha, anyway, so this was for caution.
The senior is late and the matter may come after Bihu. Not so this is not for quashing. In fact, it is for prayer for release of certain document and defreezing of the account. However, the account has already been defreezed with regard to certain documents. Since appeal, we have filed the appeal. The petitioner has got acquittal. So appeal is pending. To that effect, they have filed this.
There was a PC Act case.
PC Act.
Investigated by CBI.
Yes.
And then
Yes,
there was an acquittal.
There was an acquittal.
There's an appeal against acquittal.
Yes, your lords.
He's seeking release of those freezed accounts.
We have already defreezed. The trial court has already defreezed and order has been passed.
Okay.
Now the question is with regard to the document seized from his house or certain document during the course of investigation CBI has seized. So they wanted those documents. Our concern is that since appeal is pending, so let it come for hearing since their senior is not here. So I am not going
for return of those documents.
Yes, return. But initially they have also
Records have already been defrozen.
yes.
So-
But earlier prayer is to defreeze the account. Meanwhile, it is already
Part of
defreezed.
their prayer has already been
Already
satisfied.
succeeded.
They want the other part is the return of the documents.
Return of the document.
Which they are justified in their own way since there is an acquittal.
Yes.
You are concerned because the appeal is pending.
Appeal is pending. Only this is the situation as of now. Now it is. However, no list of the document has been filed here. That which document they need so that we can at least testify if it is not required.
Still do it. File an additional affidavit and give the list of documents which you think has been seized. If you have that.
Caesar memo is annexed.
Caesar memo.
However.
Anyway, your good name, please.
J. Saikya.
J. Saikya, learned counsel. That submits that the leading counsel is unavailable at this time and seeks an so could not appear today and seeks an adjournment to be listed after the new vacation. And Kumari learned retainer counsel CBI. Submits that pursuant to the acquittal of the petitioner in trial before the learned special judge CBI. He is seeking defreezing of accounts and return of documents. It is further submitted that the accounts in question have already been defrozen by the CBI. But the document part is remaining. And in the context of the same, it is submitted that the CBI agreed by the judgment of acquittal as preferred criminal appeal against acquittal before this court. Should we mention the number of the criminal appeal? If it is available.
It is there.
Otherwise, not mentioned.
I am giving you.
Within bracket, criminal appeal number //.
Criminal appeal 3048/2025.
48 of 2025. It is also submitted that though seizure list has been, I am narrating this for the benefit of the next date. Suppose it is another court. So they will have some guidance, what it is about. So that's why I'm narrating.
Yes.
It is also submitted that though seizure list has been submitted, but the list of documents which the petitioner is seeking back has not been mentioned. The petitioner side is at liberty to enumerate those documents to an additional affidavit. You think about it. I think it may help.
Feel so
It may help. you have track of those documents, then you can file, that will help.
In that event, clarity would be there.
Clarity would be there. Will be done. This is the matter after the view holidays, on a date to be fixed by registry.
Yes,
On a date to be fixed.
or as per their convenient time, because
You
they
want
are
the date of, let registry fix it.
much of it.
Yeah, it will remain in admission column only,
Admission.
admission column. Or should we admit it and post it for hearing?
So let it
25
be
method.
admitted.
Is it
Let
20?
it be listed for hearing, Your Lordship.
Should I admit it? I can
have to-
admit it also. Okay, you are not sure. So anyway, doesn't matter. Listed in the admission column. That's all. Okay, happy view.
Thank you. Same to you, Lordship. মানে কি হৈছে মই বুজাই দিওঁ তোমালোকে চিজাৰ মেমো দিছা চিজাৰ মেমো স্পষ্ট নহয়